Okay, you ready? Okay, let's roll.
Top of five, tomato. Come on up.
Are you ready?
Yeah,
What's the extent of what you can? Can you look up everything? No, nothing? Are you,
I get a report,
can you look?
that's like intake, but it's not accurate, so it's better for like looking up,
No, but can you look up licenses, whether they're eligible or not? No? Okay. All right. Mr. Cavazos, you're charged with driving while your license is suspended or invalid. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
yes.
Okay.
On June 29th of 2026, officers dispatched, in reference to concern for welfare. The officer advised to other officer that she had observed the defendant seated in the driver's seat of a motor vehicle stopped in the lane of traffic where vehicles were backed up behind him. The officer asked the defendant where he was coming from and stated the defendant stated he had come from a friend's, denied drinking, using drugs, and explained he was tired after getting off of work. NCIC and TCIC confirmed the defendant's ID when asked for Texas driver license and showed his license to be suspended. Additionally, no proof of financial responsibility.
Does it say whether he had the odor of alcohol or anything?
I'll check the things.
And then do you see a license,
Yes, Your Honor, I can run it right now.
please?
Who's it on?
Cavazos. Yeah.
No, it doesn't say there was an odor, I just said to get to.
Mr. Cavazos, I'm going to find that there's sufficient probable cause to go forward with your case. As a condition of your bond, you were ordered not to drive. I don't give a rat's behind what you have to do in this life. You do not have a Texas driver license. I don't know if you have insurance or not, but until you have both and you can show it to us, do not drive. We'll be signing an affidavit with you today. This is a promise that you're going to make to me that you're not going to drive. I don't care that you need groceries. I don't care that your daughter has to go to school. I don't care that you have to go to the hospital. Do not drive. This is an affidavit that you're going to promise with me today. You do every single time. It's an offense in and of itself, and I can hit you with contempt up to 180 days and a $500 fine every single time. Do you understand?
Yes, sir.
I'm just asking you to follow the law. I'm not asking to split the atom. If you're able to get a license and insurance, come back and we can talk. But until that time, if I find that you drive, you don't have a Texas driver's license. Do not drive.
Yes, sir.
We are going to reset your case to give you time to hire a lawyer. I will have you come up here, swear to us that you're not going to drive. We will have bond conditions created for you to sign. Once you sign them, at that point, you'll be free to go. Do you mind no driving, please?
Yes, Your Honor.
Thanks. Okay, come on.
All right, Judge, next is page 12, McCartan. Come on up.
So what page, Victoria?
12, file number 12. Yes.
All right, good morning, Mr. McCarter. So you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Is there a co-defendant in this case?
Yes, it's already here and already was arraigned.
Okay, all right, please.
On June 29th, 2026, officers dispatched to 5105 Bissonnette Street, which is an HEB in Harris County, Texas, in reference to a theft. Upon arrival, the officer made contact with the two suspects and asked if they paid for the merchandise inside their HEB shopping basket. Both defendants stated that they didn't pay for the merchandise in the basket. Both defendants were taken into custody without incident. The total of the stolen items was in the basket was $202.81.
But did someone see them concealing it? You didn't see.
Let me.
Did you say that or no?
All I had was that they had, let me check my notes. They passed all points of sale without, being told.
But did someone see them concealing it? McCarter,
It's just the notice. I don't believe they were looking at, but they just had it in the basket.
I mean, how do they know that they're stealing? I mean, they're not clairvoyant.
The suspects were observed by the management,
There we go.
selecting the merchandise, placing them into the basket.
Okay, but that's just. So at that point, they pass all points of sale without,
Yes, Your Honor. And then they exited passing all points of sale without paying for the merchandise. So they
Yeah.
observed placing the items and then passing without paying.
got it. How much was it?
$202.
Okay.
And
Mr. McCarter, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you're ordered not to go to any HEB whatsoever for any reason. This is not a revolving door. Do not pick up any new cases. Do not violate bond conditions. If I have to put you in jail, there will be no more PR bonds. Do you understand? Okay. How old are you, sir? We will, do you need a court-appointed lawyer? Or you have the ability to hire a lawyer? Okay. What do you do for a living?
I'm working.
You're working now.
Now I'm working in the trade school.
Are you actively enrolled in trade school? Are you thinking about trade school? Are you?
Yeah, I think I'm do my high school trade.
So what are you doing now?
So, in Fleischer. Down high school.
Is this something that you're thinking about or you're actually enrolled in doing like trade school?
So,
What I want to know, you're 19, you didn't graduate high school, you're sitting at home. Are you doing anything productive? What the heck are you going to do with the rest of your life, Mr. McCarter? This is not a good way to start. At some point, you need to start thinking about the future. At 19 years old, most people have at least some kind of trajectory of where they're going to go in life. You, really, it's time to shape up and I want to see some kind of progress. You must either get in school full-time, trade school full-time, or get a job full-time. You don't get to play at home and Xbox all day while everybody else gets to pay for everything for you. It's not going to happen. Do you understand? As a condition of your bond, you are ordered not to consume alcohol or illegal drugs, and you will be tested. If I find that you're using illegal drugs, including marijuana, then likewise, you will go into custody. I'm telling you now that you're going to get tested. It's not a matter of if, it's a matter of when. On day 50 from today, you will be tested. Do you understand? So if you put something in your body and you don't know what it is, it's probably not a good idea. A lot of this life is who you hang out with. Do you understand? There's no mistakes. There are choices. You either make a good choice or you make a bad choice. And a bad choice may land you with me. And if you don't have anyone to pony up $10,000, $20,000 for you, you will be stuck like Chuck for who knows how long. Do you understand? In 2 weeks, you will be back here and I want to see some kind of proof of where you're heading, either enrollment into trade school, job, or some kind of school, and nothing on a bar napkin, something on legitimate letterhead that you're actually doing worthwhile. Do you understand? Okay. Do you mind giving an application? I'm gonna have you sign a receipt and then I'm gonna have you meet with pretrial and then we'll see you in 2 weeks.
All right, Judge, next is page 20 and 21. Trinidad? Go ahead and see it on the button.
Good morning, Mr. Trinidad.
Good morning.
Ma'am, you're charged with assault of a family member and criminal mischief. On both of those, you're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am. Okay.
On June 29th, of 2026, deputy responded to 12123 Swan Creek Drive in Harris County, Texas for a family disturbance. Witness one, Victor Sanchez, stated his stepdaughter, the defendant, was breaking items inside the house and assaulted her mother. The complaining witness, Enid Barnes, stated she told the defendant that dinner was ready, at which point the defendant became angry, threw food, grabbed complaining witness by the hair, spun her around, and pulled her to the ground while continuing to pull her hair. The complaining witness reported pain and had visible redness and scratches on the right side of her chest. The witness one separated them, after which the defendant walked through the residence, throwing items and breaking multiple dishes, a table, and a Samsung TV. The complaining witness and witness one estimated the damage at approximately $1,800. The defendant was identified by a Washington driver's license and previous booking clerks.
Does this say whether alcohol or dope played a part?
I'll check again.
I'd like to know, do you mind reaching out to the complaining witness to see if there's any kind of issues, alcohol or any kind of dope, and then so that we can actually
Yes, Your Honor.
get a kind of grip on what's going on?
Yes, Your
Ms.
Honor.
Trinidad, and then do we know whether they want to have contact or not?
We have not spoken to the complainant yet, Your Honor.
Ms. Trinidad, I'm going to find that there's sufficient probable cause to go forward with your case. As a condition of your bond, you were ordered not to consume alcohol or illegal drug. You will be randomly tested. I want you to understand that I'm going to protect my community at all costs. I don't care who you are. I don't care how old you are, what color, your gender. You endanger my community. It's just not going to go well for you. I have no problems putting you in custody with a $2 million bond. Do you understand me? Yes or no?
Yes.
I don't know whether the complaining witness wants to have contact with you or not. Until that point, I'm ordering you not to have any contact with this person. I like to follow the wishes of the complaining witnesses. There is a protective order that has been issued and you need to get to know it. If you violate the protective order, they can file additional cases against you, including a violation of a protective order, and that is the capital murder of misdemeanors. Do you understand? How do you support yourself, ma'am?
I'm unemployed at the moment. I've been unemployed for the last 3 months. I was doing, break, taking a break at my parents' house. I used to live by myself before that.
Okay, it's time to get a job. When people have too much time on their hands, they become self-destructive. It is time.
Also, when you have.
Stop, stop. I will appoint you a lawyer today, but you will be back in 2 weeks and I want to see what you have done to get a job. If you've done nothing, it will not go well between us. Do you understand? You got out of jail because we gave you a free bond. It's not a revolving door. If I have to put you in, there will be no more PR bonds for you. You understand?
Absolutely.
Okay. I have an affidavit on file already, so if you don't mind appointing her a lawyer, and then we'll see her back in 2 weeks. I'm gonna have you sign a reset. We'll meet with pretrial free bond conditions, and then we'll have you back in a couple of weeks.
Thank you, Your
Please,
Honor.
ma'am.
Cavazos, Judge Spencer for now.
Okay. Have you heard from Mr. Flood? 9:30? Hey, are you ready? Jury's here. We're all ready. Yeah, all right. Okay, not a problem. All right. Yeah, when you get here, we'll talk, but I'm just seeing where you are because we're ready. Okay, okay, all right. All right, bye.
That's it.
Hey, there are no THAs? Mr. Flood's on the way, so in a couple minutes he'll be here and then.
We don't need to sign.
Want a copy of it? Now before reset,
Who's this?
all okay. We have a information on that one. Yeah.
Zero to one.
Hi, good morning.
I think it was time to do it. No, I think they don't request.
You need me?
Yes, please, Judge.
Talk to me.
I spoke to the chief. We did get confirmation of their expert's availability on Nichols for August 24th.
Okay. Yeah, yeah,
Okay.
sure.
I will
Yep.
get that date.
We'll set it
Thank you
for
very
that.
much, Judge.
Okay, for sure.
Councilmember Richter?
There is five.
Yes. Okay, so Miller is discovering something. What is it?
Just.
How's the August 5 or 6? They're over the controls. August 5 or 6.
Six thirty.
And the other one is that?
Office, here, office. No, still isn't good. They can go finish it. I'm listening. That's the case.
One second. Oh, yeah. Okay, so.
Guys, we're about to start trial. So if you need to use your phone, if you have to do anything that requires noise, please step outside. We're bringing a jury in about 5 minutes, please. You need to talk to me now. We're about to bring a jury in.
Okay, Arlo, AREVALO.
Okay,
Remember, he was accepted as a PT from the team race today. We submitted his non-driving affidavit, so if you can continue expenses.
okay, we're sending him now. Okay, so we'll give you a couple weeks.
Okay. So, PONCE.
Okay,
For him, everything is submitted. He had his appointment on 7/2. So just lawyer proof of device, which is waiting.
so let's just wait for the supervision order. Everything else is done. Okay, let's just hold on it. I'm not going to reset it till we,
Okay.
is that it?
Yes.
Okay, thanks. Ramon, are you here? Yeah, okay. Mr. Flood,
Yes, sir.
did you want to talk about something prior to bringing the jury in?
Yes.
Ms. Shaw,
Brasky filed a
Can I borrow
motion
you?
in limine, and I think she's gonna address it.
Okay.
If that's okay.
Ms. Brasky, are you ready? Okay.
I say this for him. She found here. And they're still looking. Just do the file here. Oh, wait.
Hey, Ms. Shaw, have you seen the motion in limine?
I'm just looking at it.
Please. Deputies, anybody who wants to watch can stay and watch, just no phones. Okay. Yeah, good. Anybody who wants to stay, please stay. Okay, guys, you ready? It's 9:45. The jury's been here for 45 minutes, man. I don't want to keep them waiting. Okay. Did you just file this motion in limine or has it been on file? Mr.
It was on file yesterday.
So you filed it yesterday then?
Yes.
Okay.
I think from my emails this morning, I think it was accepted this morning.
She went across the hall, they cleared. But it's changed, why are they not here coming in?
That's a good question.
Oh.
How soon?
I'll get an update.
But at least let's talk about the motion in limine while we wait, so we don't just let them sit and stew for nothing. And then when they get here, then we will start. But they're waiting on a chief to come for trial, but at least we can start talking about the motion in limine. It's your motion, so what would you like? Oh, are we, guys, we're going on the record, please, no talking. All right, we are back on the record in cause number 2565785, State of Texas versus Jaime Cruz Jr. We're currently in trial now. Defense has filed a motion in limine. Go ahead.
Yes, so the motion kind of speaks for itself. So first, the first one on here is personal knowledge. We request that the court instructs the state
Sure.
witnesses, right? To only speak about things that they have personal knowledge of. And specifically also relating to scientific tests or anything that somebody's not qualified to speak about.
So, Ms. Shaw, you've had an opportunity to look at this.
Yes, Judge, I'm getting to number 5, but.
Well, the first one, I think
The
that
first
they're
one is fine, Judge.
right. I mean, it's a given personal
Yeah.
knowledge.
Um,
Also, I think on undisclosed statements, backdoor hearsay. Sure, comment on the accused silence. The only one I saw that kind of threw me for a loop is so under backdoor hearsay, the accused requests the court to instruct the state and its witnesses not to mention during voir dire, opening statement, testimony, closing statement, any statements made by any non-testifying witness, officers, EMS, civilian, other person not called to testify without first approaching the bench. Maybe that was up. Hold on. That's what I saw. But do you have any problems with any of them?
Here. There is no opposition to this. Number 3, Judge.
So 1, 2, 3, 4. I mean, I have no idea what's on the video, but yeah. So you're okay with me granting those then?
Yes, Judge.
Okay. Obviously no toxicology results because we don't even know yet if tolerance, intolerance. So far, hey, I'm granting 1, 2, 3, 4.
Five and 6, Judge.
5, 6. Oh. I guess 7 and 8. 9 doesn't apply because we've already. Well, no, I guess it would. I mean, they're asking.
Just for clarification on 7, do they mean the mention of tolerance, or is it just the way that it's reading? The scientific theory of tolerance, that some people can be tolerant to alcohol. Um,
No, it's her motion.
So that I think the state would have some form of objection to, just in the fact that the state should be able to talk about just the mention of tolerance, not in not in regards to the blood alcohol concentration, but just in the mentions of whether someone can be tolerant to the effects of alcohol. But, and I guess I'm a little confused with.
I guess here it's asking it in the event that you want to get into it, let's have a hearing to see whether we should or not allow it. So if you feel the need that it's going to come up, just let us know and then we can stop and just have a brief hearing on what you'd like to get into and why. And then I guess we can just have kind of I mean, I guess we need to see whether it's relevant or not. I don't want to just go on a fishing expedition just for the sake of having a fishing expedition. If somehow you guys can get into it and can show something or have some kind of evidence or proof, then sure, we'll have a hearing. But I don't know. Until we get into it, I don't like to just blanket say no to things just for the sake of saying no when there may be relevance for it. So we'll have a hearing to see whether it should or should not. Okay.
It is my judge,
Okay.
and mine is on judge. What was that? 9 is fine.
Yeah, I think that's it. All right. So, I think we're ready, right? To bring the jury in. So just 5 minutes for opening and then we'll start with your case in chief. Yeah, sure. So just quick opening, 5 minutes for opening.
Thank you, Judge.
Okay, guys, are you ready?
Yes.
Okay, with you guys, who's doing opening? You're gonna do opening? Okay. So, hey, Mr. Flood, 5 minutes. Okay, yeah. All right, let's roll. Are you doing opening? Are you opening?
Yes.
Okay.
All right, for the jury.
All right, you may be seated. Thank you for coming back, ladies and gentlemen of the jury. You didn't run away. I'm so very proud of you. We will try, like I said, to be as efficient as possible. Every now and then, we will have to excuse you guys. Usually that's just due to housekeeping, realize we're in trial, but we still have other business that we still take care of, just that had to try to put on the side while we're in trial, but sometimes it's inevitable that we have to take other brief, recesses. Are you guys ready for opening statements? Okay. All right, please.
Good morning, everyone. Again, if you remember, my name is Shanti Shaw. I'm the prosecutor in the case. And I just wanted to talk to you a little bit about the facts of this case since we found out actually yesterday. When I look at this case, it's really about choices and consequences. In life, we make choices all the
I'm gonna
time.
object, that's argument, improper opening statement.
Say it again.
Choices and consequences, Judge. We make choices every
Overruled. You may continue.
And the consequences of our actions, most of the time it affects us and the people that are closest to us. When it comes to driving, however, our choices and their consequences affects everybody on the road, right? It's not just us. When we choose to disregard traffic signs, when we choose to speed, it can have an effect on anybody who's on the road. It can change people's lives in a
Yeah, I'm
second.
sorry, I'm gonna object, this is argumentative, not talking about the anticipated facts.
Yeah, that's what the evidence will show.
Yes, sir. In this case, the evidence will show you that the defendant on May 24, 2025, decided to get behind the wheel after a night of drinking. Admittedly, he had a 6-pack of beers, and after that, he chose to get behind the wheel. You'll hear from the deputy who made the stop. When he observed the defendant speeding over the limit, about 20 miles over the limit, and he made the stop. You'll hear from him what made him decide to start a DWI investigation, what he saw, what he heard, what he smelled. And you'll also hear from Deputy Allen, who got the custody of the defendant and took the defendant to the station and was able to collect a sample, a breath sample.
Here.
Yes, Judge. That's pretty much it.
Okay.
You'll hear about the findings. You will also hear from the experts in this case who are familiar with the test and how it goes. They're familiar with the machine and how it works. And they will explain to you their findings of that night. And I'm pretty confident that at the end of this case, you will have enough evidence in front of you to be able to see how the defendant not only had lost the normal use of his mental and physical faculties due to the introduction of alcohol. But basically also was over the limit. So,
I'm gonna object, that goes towards what we had discussed, emotion and limiting.
Yeah, just let's,
yes,
Right. all right, sustained.
So at the end of this case, I'm going to come back to you and I will go over the evidence that we will present to you. And I will ask you to find the only verdict that will be supported by evidence in this case, and that's guilty. Thank you so much.
Thank you.
Man,
Please.
so I respect the state, but getting up here when, you know, the evidence, they're gonna try to saddle a person with a criminal conviction for the rest of his life. Being pretty confident, that's not proof beyond a reasonable doubt. Y'all are gonna get to judge the weight of all the evidence, the credibility of the witnesses, all of that matters. I think it's gonna be interesting. What you're gonna see is, so this is precinct 4 constables and Deputy or Corporal Ryan is on a freeway, following Mr. Cruz's truck. And he says he pulls him over for speeding, and you're gonna see other cars going by even faster than the officer, faster than Mr. Cruz. But for some reason, he's focused on Mr. Cruz. You're not gonna hear any evidence of like a 911 caller saying, hey, there's a drunk driver on the road. You're not gonna see a person swerving all over the road. You're not gonna be able to look at the driving and say that person looks like they're intoxicated. But he pulls them over anyway. They go to a gas station. The officer, the Corporal Ryan, asks for backup. He is, I think you'll hear common practice as you call for like someone to come out to do the DWI investigation. You call for backup, like a special person, and 3 other constables show up. And he chooses to go with Deputy Perez. And I'm anticipating you'll hear from him. And he's supposed to be the guy that's the DWI guy. And I'll let you hear what he has to say and all about his knowledge. But Deputy or Corporal Ryan is the one that actually does the tests. And you'll get to see this on video. I'm very confident that there's nothing about this video of an individual doing these unnormal, kind of awkward balancing tests. There's nothing on there that you're gonna look at and say, I can tell for sure that that person is intoxicated. That's not this case. Nobody falling down, no vomiting, nothing like that. That's not this case. There's gonna be some issues. You'll probably hear me object a few times. That's my job. But the video and the arrest decision, it's not gonna be enough to convince you of a person who was guilty of DWI. If you do hear of any BAC number, listen to the testimony really carefully, because what matters is that they've got to prove what the BAC was at the time of driving, not at some point down the road after the person was driving. And there's a way they can do that, but only if they have certain information. If not, their answer to you is going to be, I don't have any proof of what Mr. Cruz's BAC was when he was driving. And just keep in mind, this isn't just a person on trial for allegedly being intoxicated. They've got to prove driving while intoxicated. And at that time that he was driving, they can prove beyond a reasonable doubt he was intoxicated. So, you're also, last thing, and I'll sit down, Mr. Cruz's, first language is not English, it's Spanish, and both of the deputies that you're gonna hear from, I think you're gonna hear them say the same thing, that English isn't their first language. But you're gonna hear evidence of slurred speech. You're gonna get to watch and listen to this on your own. And you're gonna hear strong accents with all the parties. So you gotta decide, is that really slurred speech or accents coming into play? But you're all gonna get to see everything and judge all the evidence. I just ask that you keep an open mind until the end. Wait to hear all the witnesses before you make any decision. And I'm confident that you'll do the right thing. Thank you.
Thank you, Mr. Flood. Okay, State, you ready to call your first witness? Okay.
State calls, Officer Zachary Ryan.
Did you say Ryan?
Officer Zachary Ryan.
Okay, guys, want to grab me?
Yeah, I'd like to vote for roll.
Okay, guys, the rule is invoked. Are there any witnesses in this case in the audience? No? Okay, all right. Good morning, Deputy. Coming up.
No.
Hi, good morning. If you would please raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God? All right, come take a seat. If you would please testify loudly, clearly. If you hear the word objection, just stop until it's been addressed, and then you may continue.
Yes, sir.
Okay? All right. Please.
Good morning. Could you please say and spell your name for the record?
Zachary Ryan, Zachary, Ryan, Ryan.
And, would you please tell us what your rank is?
I'm currently a sergeant with the Harris County Counsel's Office, recruiting forward.
Sergeant Ryan, how are you, I mean, you already said how you're working for, but, how long have you been with Constable, Precinct 4?
10 years now.
And are you assigned to a particular area?
I'm currently assigned to the North Patrol Division, as well as the Active Investigation Team.
Do you receive any, training in handling DWI investigations?
I have,
Would you please tell us about that?
both in the basic Peace Officers Academy, as well as taken the SFST refresher course 3 times now.
Do you, receive any specialized, training regarding, intoxicated drivers? Pertaining to intoxicated.
Correct, both in the academy as well as those field sobriety refresher courses.
So let's talk briefly a little bit about the training that you have received. When you detect a intoxicated driver, are you trained to conduct field sobriety tests?
I am.
And what are those evaluations called?
The standard field sobriety test, the specific test,
Yes.
horizontal gaze, nystagmus, the walk and turn, as well as the one leg stand.
Did you receive any certification for performing the field sobriety test?
I have,
Could you tell us a little bit about that?
both in the academy, and then I've taken that refresher course 3 times, where they make sure you're proficient in giving the examination.
Does the certification include field and classroom training?
It does.
Has all your training, would you say that your training has allowed you to identify signs of intoxication?
It has.
Now, let's talk about identifying intoxicated drivers. Can you approximately tell us how many times you conducted evaluations on people suspected to be intoxicated?
I don't have an exact number, I'd say probably hundreds of times.
In your experience, what are the classic signs of intoxication?
On a person themselves?
Yeah.
The odor of alcoholic beverage, bloodshot eyes, unsteady on their feet, difficulty using their hands to, manipulate things like with their wallets.
What are the physical signs? I think we covered it, right?
Correct.
So when you come across someone exhibiting these signs, what are you trained to do?
If there's possible intoxication, I would have them step out of the vehicle and see if they would perform field sobriety test.
And what is the purpose of the field sobriety?
Trying to determine their level of intoxication.
Have you ever pulled someone over where they asked them to perform a field sobriety test and determine they're not intoxicated?
I have.
Would you tell us ballpark how many times that has?
I'm sorry, say it again.
Would you tell us ballpark, maybe how many times that has happened?
Yeah, I'm gonna object to the relevance and bolstering regarding people that he hasn't arrested.
Yeah, let's stick to the case at hand, please. Sustain.
So I want to direct your attention to May 24, 25. Were you on duty that day?
I was.
And what shift was that?
I worked my regular shift. I worked my regular shift that ended at 10 p.m. and then starting at the 23rd on 10 p.m. I started the GWI initiative shift, which went through 6 a.m.
Were you in uniform?
I was.
And were you in a patrol?
I was.
Could you tell us, you were saying that you were on a DWI initiative. Could you explain to us what that means?
The department puts out extra units to patrol for reckless drivers and intoxicated drivers.
And how are you trained to spot that?
Through regular traffic stops, making contact with the drivers.
Do you need specialized training to be on that? On the particular type of DWI initiative?
You just have to be trained in field sobriety tests.
So while you were on patrol that night, what drew your attention to the defendant's vehicle?
The speed.
Do you remember what type of vehicle it was?
I believe it was a Chevy pickup truck.
And is that a motor vehicle?
It is.
Do you see the driver of the vehicle in a court today?
I do.
Can you point him out and an item of clothing?
White button-down shirt with a blue tie.
On a record reflect that the witness has positively identified the defendant.
It will reflect.
So when you observe the defendant's vehicle, what street or highway were you driving?
We were on the North Freeway, I-45.
And is that a public place?
It is.
Even there's down place.
It is.
What was the speed limit on the roadway?
Supposed to be under 65 miles an hour.
And could you see posts that have the speed limit clearly shown?
Correct. There's many up and down the freeway.
And I'm not sure if I asked you, what was the speed limit? You said
65 miles an hour.
65. And what was the defendant's speed?
I had 85 miles an hour.
How were you able to verify the defendant's speed?
Utilizing our in-car mounted radar, so it's Docker dual SL radar.
Can you explain what that radar shows you?
Basically, there's an antenna, send out radio waves that bounce back and are able to give the speed of the vehicles.
And what did you do at that point?
After following him for a short while, initiated a traffic stop.
And when you approached his vehicle, what did you notice?
There's over alcoholic beverage coming from the vehicle, as well as he had some red bloodshot eyes.
Hold on. Hold on.
Yeah, they're not much of this.
Yes, please.
Sergeant Ryan, do you recognize this? It's this exhibit 1.
I do.
And what is it?
It's a CD containing my body-worn camera from that evening.
How do you know that?
We reviewed it prior to trial, and that's initialed it after reviewing it.
Do you do you believe that it will show, it accurately depicts what happened that night?
I do,
And has it been altered in any way?
not to my knowledge.
Judge Merritt, Judge Merritt, will be fair.
May we approach?
Sure.
Go ahead.
To object this video can be. But I'm using this particularly. Things contain those reactions from like. Subjecting to the raising emotions.
Okay, so we can, we'll have a hearing on the HDM and everything. Let's just talk about the video at the moment. 'Cause, I mean, we can get into everything prior to the SFSTs, but which video does it have there that you're trying to make? Is it the one that's with redaction?
It has the election and.
No, but is it, does it have the redactions that he's talking about?
Yes,
It does? You want to take a look at it real quick, just make sure?
Yes.
Okay, how long does it take? And how many redactions are there?
5 parts and 5 parts.
So how long do you think, can it give the jury today? That long?
Less, not up to as fast as I
Mm. Okay, hey. Do you mind taking the jury out for 5 minutes? Okay, sorry, ladies and gentlemen, there's a jury, we just had the housekeeping matter, give me 2 minutes and then I'll have you brought right back in.
All right, so the jury.
Don't go. All right. Yes. Remember. Mr. Flood, once you have determined the redactions are in place, then there's no objection, right? Other than what we,
I still have objections. The HDN and. then-
sure, no, right, aside from that.
Objection, about, the arrest. Time.
Okay, well, let's do first things first. Just go ahead and look at the redaction so we can at least start playing it for the jury. Ms. Shaw, does this witness administer the HDN?
The whole field, so.
Okay.
Ms. Frasky's looking at the redactions. She just made a suggestion, but I don't think you want to do this right now. But we could also deal with the HGN right now, but
Well, let's look at the video, see if that's at least good, and then we'll do the HDN after.
Council office, do you know your insurance?
Bless you.
Hands by your side. They're down the hot end of it. Want you to take your left foot, put that line, foot on the line, okay? Take your right foot, you. Want you to imagine a straight line going that way, okay? Yep, imagine a straight line, okay? No, see where you're at. So that's what I'm saying. I want you to take your left foot, put that line, foot on the line, okay? Take your right foot. Come over here, sit on my push button right now.
Okay, Judge, we don't have any objections regarding the redactions that were made, other than I'm still objecting to the.
Okay, you want to do the HDN now, so we can just get it done?
Yeah.
Okay,
Okay, so take a few minutes. but-
I understand, but might as well be efficient, right? Okay. All right, Ramona, you ready?
Yes, sir.
Yeah, okay. Did you want to go ahead and take the witness now?
If you don't mind.
Yeah,
I'd
All
like
right.
to, so I'm gonna raise a motion to suppress the HGN. And I'd like to ask Corporal Ryan some questions, and also if the state's moving to admit this video, I don't have any objections to the redactions, but I'm objecting still to certain parts that remain. One is the HGN and another is probable cause for arrest. But I'd like to be heard on the HGN first. And
floor is yours.
State's Exhibit 1, I'm assuming. Right. We can do from the flag. Can we get it off? Okay. Sure. Is it, so was it ever Corporal Ryan?
It was corporal at the time, sir.
And is Sergeant above or below?
Both.
Oh, it's
Yes, sir.
much on. I want to ask you some questions about the HGN administration that night, okay?
Yes, sir.
So you're familiar with NHTSA, you've been trained in the field sobriety testing, correct?
Yes, sir.
I have two manuals. You need to refresh your memory or something. I'd be happy to lend you a copy, okay? I'd like to first talk to you about how you properly administer an HGM, okay? And then compare it to how you performed it on the occasion in question on May 24th, 2025, May 24th.
Yes, sir.
Okay, so NHTSA, National Highway Traffic Safety Administration, that's NHTSA, that's an acronym we use to, we talk about the governing body that is authoritative on the subject of field sobriety testing, correct?
Correct.
And then in your training, you received a training manual, and that manual is authoritative on the subject of field sobriety testing?
Yes, sir.
How to administer the test properly?
Correct.
Okay, and there's three standardized tests, right?
Correct.
And only three that have been validated, right?
Correct.
And that's the HGM, the walk and turn, and the one leg stand.
Yes, sir.
So standardized meaning that, so for these tests to have been proven to be valid, they must be administered in the standardized manner, correct?
Correct.
Everybody does it the same everywhere, right?
Yes, sir.
It's not just Corporal Ryan's way of doing it, it's the NHTSA guidelines, correct?
Yes, sir.
And if you, in order for the HGM to be valid, it must be conducted in accordance with the standardized NHTSA guidelines, correct?
Yes, sir.
Okay. So I'm just gonna write down HGN. Can you describe for me what, for a proper HGN, what's the first thing that you do?
The medical check.
Pardon?
We'll get him in stance first.
Get them in stance, okay? Stance, so there's some things you do to qualify them? Or before you begin the HGN, there's things that you do?
Well, I'm talking about asking questions prior to.
Yes, just,
Yes, sir.
so you get them in the stance.
Correct.
What do you do next?
Once they're in the proper stance, then you do the medical check.
Medical,
Medical check, people size, check arrest and nice items.
okay. People size and resting nystagmus.
Yes, sir.
Okay, and then what else do you do?
Then you move on to check for equal tracking.
Okay, how did, you said equal tracking?
Yes, sir.
And how do you check for that?
You hold your stimulus, whether it be your finger, hand, 12 inches from the face, and go about 2 seconds out, back and forth, twice on each side.
Okay, so you take the stimulus and,
Just better show or explain, sorry, I'm not,
no, it's okay, I'm trying to write and listen, but are you counting going to, so which direction do you start moving?
move to the right,
To your right?
yes, sir,
Okay, and you go to the right, and then you go to the left, and when you come back, you're counting that as one pass?
correct, I do one pass,
Okay, just want to make sure that we're not calling that two, but okay, so you hold it 12 inches away? Below their eyes, at their eye level?
about eye level,
Pardon?
eye level,
Eye level, okay. And then you move it to your right first,
correct,
and you said approximately 2 seconds?
correct,
Like approximately 2 seconds to go out?
correct,
Okay, and then you moved it to your left,
correct,
and then what? Do you just, so that's like one pass, right?
correct,
And you just do one pass to check for equal tracking?
2 passes,
Okay, so you're supposed to go then to the right and the left again.
correct,
Okay, and that would be to check for equal tracking.
correct.
Okay, and then what do you do next?
Last smooth pursuit would be the next, which would essentially be the same.
I'm putting LOSP for lack of smooth pursuit. Is that okay?
Yes, sir.
If you disagree with anything that I'm writing, let me know, okay?
Yes, sir.
And what do you do? What are you supposed to do for a proper HGN check for lack of smooth pursuit?
It's essentially very similar to equal tracking. Right to left, 2 seconds out, 2 passes.
Okay, so same thing, right, left, right, left. And you said approximately 2 seconds. But, yeah. That means like it's approximately 2 seconds, okay? What are you supposed to do next?
We look for distinct and same assignments at maximum deviation.
Okay, I'm gonna write down max for short, okay? And how do you check for that?
The same pass pattern right to left, but when you go out to the eye, you hold it out for approximately 4 seconds.
Okay, approximately 4 seconds. So
4.
3 seconds, 3.5 seconds would be fine according to NHTSA.
I'd have to look the manual or called. They say about 3.5 seconds.
Sorry,
Just for 3.5 seconds, 3 seconds, I can look at the manual route.
okay, I can, may I have a question with you?
Sure.
I can give you this, I think I got some tabs there and, session 8. You're probably familiar with, that's where they discuss HDN administration. So you do this how many times? So this is one pass checking for distinct and sustained nystagmus and maximum deviation. You do one pass for that?
It'd be 2 passes.
2 passes? Okay. And so what are you looking for when you score that clip?
For the next dive must be the thing's insane, but while you hold it out, approximately shoulder width. Make sure that status is sitting there.
Okay. And then is that the end of the test?
No, then you have onset nystagmus, prior 45 degrees.
Okay, so I'm gonna write down the less than sign, probably prior to 45 degrees. And how do you perform, how are you supposed to perform that set of passes?
The same pass pattern, but you go out at a rate of about 4 seconds, trying to see if you see that nystagmus prior to 45 degrees. Approximately.
Out at about 4 seconds? Correct?
Correct, moving at a rate of about 4 seconds.
Okay. And so I noticed that, so these would be for equal tracking, right? And these two would be for lack of smooth pursuit. These two would be for maximum deviation, and these two would be for onset prior to 45.
Yes, sir.
So why are you supposed to check each eye twice with 2 passes?
The reason why I'm not positive, I don't recall.
But that's required
Correct,
by NHTSA, right?
correct,
Not just one pass per eye, right? NHTSA dictates you've got to perform 2 passes to check for each of these 3 different things, correct?
correct.
Okay. So you're saying this would be a proper HGN?
Yes, sir.
Okay. If you look at section 8, are you, I'm sorry, session 8? When's the last time you've had an update
That would have been in January.
Okay. If you look at section 8, this dictates that, so there's some approximations of time on these other passes, but when you're checking for distinct and sustained nystagmus and maximum deviation, that's the one that's got like a strict timeline. You have to hold the stimulus at maximum deviation for a minimum of 4 seconds, right?
That's what says,
Well, I don't want to be the one. You're the one here testifying, right, as the one who's trained and who administered them, correct?
correct.
Can you look through there and see where it says that in section 8? It's a couple places. Mine's a little different than yours, but. Find it.
Correct.
What page you look?
23 in this manual.
Session 8, page 23.
Correct.
Okay. That's one place where it talks about it. And it states when you're checking for distinct and sustained nystagmus and maximum deviation. It's evident when the eye is held at maximum deviation for a minimum of 4 seconds. Correct?
Correct.
Okay. And then when you go on, there's more instructions about how to, like a summary of the instructions. But the 4 seconds is the one that's required. That's the only one it's got to be at least 4 seconds, right?
Correct.
So not 3, not 3.5. That would not be in the standardized validated manner, correct?
Correct.
And do you know why it's 4 seconds?
I don't recall.
Okay, in your training, when did you go through the basic?
Basic Academy was, would have been the beginning of 2016, January through May, I believe.
15?
16, sorry.
And is that where you received your NHTSA training?
Correct.
Okay, so do you remember them training you that the reason it's 4 seconds on max is because some people who are not intoxicated will exhibit nystagmus, distinct and sustained nystagmus at maximum deviation for a few seconds, but it'll go away after 4 seconds. Does that ring a bell?
It does.
Okay, so the reason 4 seconds is important is because if you only held it for 2 seconds, 3 seconds, anything less than 4, you might be counting a clue on someone who's actually not intoxicated, right?
Correct.
Okay. All right, and on this occasion, are you saying that you administered the HGM on Mr. Cruz in this manner?
That's my recollection.
Did you watch the video before testifying here today?
Some time ago, this was.
Okay. Did you have a chance to review your HGM administration?
Yeah, some time ago, yes, sir.
Did you form an opinion about whether you did it correctly or not?
To the best of my recollection, yes, sir.
I'm assuming your opinion was that you thought you did it correctly?
Yes, sir.
Okay. Your Honor, I'd like to publish states, has it been admitted yet?
It is not. We're waiting for the redactions.
Judge Marion, move to, admit state exhibit 1.
Any objection?
I don't have any objections about the redactions, but I am not waiving all objections.
Sure, of course.
Going forward.
I understand. We'll get to
Okay.
Yeah.
So I'm waiting.
it.
But for the purposes of this hearing. I don't have
It's
any
right.
Objections at all.
Yeah. All right, you can go ahead and publish so we can,
Okay. Beautiful time.
Yes.
and then I don't know if you guys want to maybe kind of tweak the TV this way so everybody this can see it also. Sure, yeah.
Okay.
Yeah, Judge, I'm going to mark this for demonstrative purposes as defense exhibit 1.
Okay,
I'm not asking it to be admitted right now, just
for demonstration.
demonstrative purposes.
It's one button. It's one button. I think it was toward the top when Ulysses hit it yesterday.
Well, this was a different setting. This is part of the video.
I'll watch it there. You want me to call him? Hey, can you come back and help us one more time? We're trying to play a video. Wait. Yeah, do you mind, please? Thanks. Okay, cool. Bye. And don't, when you're done, just leave it so that we can have the jury ready when we get to the rest, please. Ramona,
Did you call me?
I sent you a text.
No, the problem is that we shows on this.
Yeah, you just put one right down there.
Now we push every single one.
On there, on the other one.
Yesterday, push the DVD, but my computer was attached.
Sorry.
Now
Sure.
it's. Yeah, because it's. But the DVD was on the computer, but it was down on the computer. It's just, I don't find that. I don't know where the cord is, that we need this.
Yeah, she's got.
Yes, it's plugged in, it's just not.
Well, she tried to. Could you mind if we try plugging in?
No, of course not.
Is it on the screen? Okay.
Hey, thanks, Jesus.
Well, someone's not option go now. I don't know if it's gonna do it. Okay. Treasure be there. Yeah, I think this one is three. I was just going.
The kid.
Are we allowed, is there somewhere where how we can play it from ours, or we just need to stick with theirs? So we won't play. Well, we haven't played over here, but we said this input isn't compatible with this.
It's not compatible with the Mac.
Oh, yeah.
The Mac doesn't work with the Mac.
Oh, we're using a PC there.
Oh, is it a PC? Oh, yeah, then it should work.
Yeah, in my cable, it should be fine. We had it, do your one button magic like you did yesterday. Can try. Well, maybe, can you skip around for a few minutes? We're done. Oh, yeah. So it's 30 years.
It is smaller, so I don't. So yeah, it's showing, again, it's showing on the screen, it's not nice. That's technology. Right. I'm here in the order.
Is your computer not working?
It's the adapter, George. We'll have us, very new adapter. We don't HDMI to USB.
If it's not gonna work, I mean, they've been out there for a long time. Let's just do it on theirs so we can bring them in.
We'll put it here. We're only happy to use for this one, we have this one PC, so we won't have any technical issues.
It's inevitable.
So our devices are too old to the screen section. To use this thing, so if you know how.
Yeah.
We have like
Mr. Pollen.
Okay, Judge, I'm coming.
Yes. Nineteen eighty, 1990. Right, that's what I'm saying. So they're good too old. This is 2 years, guys, still. They have to be looked at.
You guys ready?
You can see it's blowing up. We're doing that on ours.
All right, wonderful.
So actually, are you?
Okay, this is State's Exhibit 1. I'd like to start it at approximately 5 minutes and 50 seconds on the media player time.
Shh. Okay, you ready? All right. Okay, you may continue, Mr. Flip.
So, Corporal Ryan, I'm gonna play it through so you can watch it, and then I'll just ask you a couple follow-up questions, if that's okay.
Yes, sir.
But I'd like for you to watch your administration and see if you notice any deviation from the validated, standardized manner, okay?
Yes, sir.
Do you see that right?
Just now.
Should be.
So we can't get the volume to work.
Okay.
Sorry, what's wrong?
Okay. Thank you, Jared.
All right, sorry, I'm sorry.
Kind of volume button that you need to push, because we're.
Every time I hit something over here, it's just.
I've been hated all the time.
Someone's turning the volume up, so that's you.
Max it out, but I still.
And it's up on your computer?
Yes.
Give me a second. Let me see something right here. Hold on. But I'm turning it down so it doesn't blast because it's on full blast. Let's try this. Oh, just give it a second. God, dog it. This damn thing. All right. Can you hear anything or no?
No.
Doesn't sound like it.
Just went off.
You turned it off.
Now it's like, you're letting off the screen.
Right. Now they can't get the sound. Sorry. Okay, all right. Bye. This is ridiculous, man. Spend more time jacking with the AV than actually in trial.
And he asked that C person if he could stick around. He said he would.
Yeah, he's coming. He's on his way. Okay. Yeah. Yeah. Sure.
Cases 185.
Yeah, yeah, it's okay.
And with mitigation, mitigation.
All of that stuff. So.
Yeah.
Welcome back.
There's always something. All right.
Morning, Mr. Robinson. It's good to see you, man.
It's not just it's like. So I'm so but yeah, so I get to my first one, now it's gonna come over. But I'll wait for the text.
Videos in this right here.
Put that line, put on. Nine, heel toe step down line. Leave that lead leg on the ground. You can see your small steps. You take 9 more additional steps to that down line. Okay, now look like this. 1.
All right, Tyler, you ready?
2, 3, so on and so forth till you get to 9.
I can't see it.
Yeah, but we can see it. So after this, don't touch any buttons. Just leave it alone. Please.
The computer. So that we can definitely get them plugged until trial over.
Usually you have this kind of film, it's spread. No.
Here we go.
Make sure it's totally just working.
Do you not leave Lego? Yeah.
This week or.
These 2 small steps. You can take 9 more down. 1, 2, 3, all the way to get 9. Okay? I want
Yeah. Weird.
I want you to count out loud. I want you to look down your feet. I want you to keep your hands by your side. I want you to keep going until you complete it.
Let's give you just one. Yeah, that guy was just slow. On speed. It's working. Exactly. That was it. We should just everybody for a little or some, because I know you know, from some of this one. That's what comes on.
All right, are we good?
Again, move here, just so you have to do that.
All right, Tyler, do you want to cue it up? Let's go. Jury's been waiting for like 45 minutes already, man. Let's go.
If you can maybe just have.
Okay, I'm gonna start at, trying to
Thank
get
you.
back to 5:15. Starting at 5:42 on the media player time, takes until go on.
And go inside. And go inside. This is my phone. Okay, follow the guys on me, okay?
I'm giving it credit to Ron, to the admin coming up. Depending on Okay.
So you don't have to.
Okay.
Okay, I'm stopping the meeting later time at 7:20. Did you have a chance to watch that posting?
Yes, sir.
Did you notice any discrepancies on how you're supposed to do it as opposed to how you administered it?
Yes, sir.
What did you observe?
Missing my second passes, on maximum deviation and onset prior 45.
So say that again, you missed,
Correct, there's no second pass on the last two.
you only did one pass for
Correct.
maximum deviation? So if I can draw a red mark through the second pass?
Yes, sir.
Okay. And then I'm checking for, this tag was prior to 45 degrees. So it looks like you went right and then left. But then you only did one pass,
Correct.
or you kind of went back to the right, but you never did a
Full
second.
second pass. Correct.
Okay. And then on this set, I don't know if you noticed when you're coming to the left, you maybe held it a second and then moved it back.
Correct.
You didn't hold it for a minimum of 4 seconds.
Correct.
Right? Okay. And then, you know, according to, this, if any of the elements of the field sobriety test are changed, the validity is compromised. You agree with that? Stated in this manual, and that goes towards the reliability of the test and the validity. It's gonna be done in the balanced, standardized manner, right?
Yes, sir.
Okay, I'll pass witness.
Okay, state.
So, as you were talking about your expertise before, have you done, how many times have you done this HGN test?
I couldn't give you an exact number, at least hundreds of times.
And, if you can tell us, if you can tell us again, what is your, certification and expertise in doing, the field cigarette?
I've taken in the academy, the SFST course, as well as taken the refresher 3 times.
In your expert opinion, the way you conducted the HGN that day, do you think it had an overall effect on the result?
Could you rephrase the question?
Do you believe in your expertise, the way that you conducted the HGN ultimately had an effect on the results?
No.
Does the NHTSA manual, allow for some sort of, or small variations?
It does.
No further questions.
Okay,
May I just,
no,
okay, based on such money, I'm going to suppress.
yeah, I'm gonna grant the motion on the HGN suppression. So at some point, we'll have to redact that from the video if and when it does go back in front of a jury or to the jury. At this point, prior to bringing let's go off the record for a second, Ramon. Lawyers, is anything you guys need before I know that you have something with Ms. Longmiles. Do you want to, before we bring the jury in, because they've been waiting a long time. When I bring him in, we're going to go. I don't want to stop. So now's the opportunity. Let's take a 5-minute break. Okay, lawyers, please. Mr. Robinson, are you here for something you need? Tell me, talk to me. Listen, now, come on, bring it, dude. Oh, let me see. Let me see. Do you know if they're gonna file it or not?
I know that the chief is in the middle of the trial for felony court, so I'm not sure, but I know they just like an email.
So what I would do, maybe go to, you know what, in the purple, she's a chief, she can file it for you. In the purple jacket, she's a chief in 6, she can file it for you. Talk to me. Hey.
Mr. Bruskin, I just waited for the plea papers. If we have a case, I got a case.
Okay, talk to me.
This is on Mr. Carrick.
Okay,
I'm sorry. I've been talking to them, but I didn't come get a straight review. This was the case with the extra discovery that they finally showed up with.
yeah, I mean, they got it for you,
They got it.
right.
So he's gonna end up taking the time. He's not gonna be-
Okay, is he here now? Okay,
He's not.
he's supposed to be.
Not today.
Yeah, except for,
I don't know.
no, maybe I'm wrong. I think I'm wrong. Okay.
You rolled me because I.
Yeah,
messed up.
okay. Pick a day next week. He's got to be here because you're at 180. So whatever day next week, but he's got to be here. Okay, thanks, buddy. Yeah, now's the time. What's the,
She just keeps demanding my Christmas.
do you have it? Do you know who? Who?
McCarthy.
Are we,
McCarter, there's 2 McCarters on document.
she said that we had already done the other one.
Yes, McCarter's holding was already finished, the, McCarter, Morian was not.
Oh, there's 3 McCarters?
There's 2 McCarters.
Well, Victoria said that we had already done the other McCarter. Because I asked her, I thought that it looked like there was a co-defendant, and so I had asked her, we did our Maureen, right?
No, we did, Colton.
That's, we did,
Mix up with defendants. There's a mix up with defendants. And you generated the PC form?
oh, this dude's on deferred for an aggravated, for an ag assault. I would have done a bunch of, no.
He's to come back.
Yeah, no. He's on deferred for an aggravated assault. I'm gonna put a GPS monitor on him and I'm gonna give him like a
Yes,
curfew.
I had called this person up, but the other defendant showed up. And he was off Docket. He was reset when he was
All right,
supposed
let me see. We'll do it. Come on, Alan. What's up?
There are two cases. The first one is listed, Justice Oman.
Okay.
That was set for Thursday. Your Honor, last year, you put the immigration request in, the immigration attorney for the MAC is on vacation all week. Since then, to approach you to see if you can set it for, if fast track money for people's office if necessary. Maybe to approach.
But have you guys done the packet yet?
So he's missing, Mr. Solomon, he's setting stuff on Sunday, so he's done
Great.
his part.
Okay.
But when I initially consulted
When is the person getting back?
Monday,
This coming up Monday?
next week.
Okay, so set it for Wednesday. He's got to see the person Monday or Tuesday.
Absolutely.
Yeah,
Because of
okay.
refugee status.
I end up just fine, but let's get it done. Okay, who's number two?
Mr. Godfrey, he's on document today, so I don't think he's there. I was up in the 176. Tomorrow, I would like to see if we can do a bond reduction.
I'm not gonna do it.
Okay.
No,
Understood.
but,
Judge had some questions about Mr. Taylor happened here, his bonds and his space here. And if he pleads guilty to everything, it could affect his sentencing. So I didn't tell him maybe he can do a bond reduction.
no, I'm not, no, right. He's got way too many cases. He's a dangerous dude. It's not just not gonna happen.
I understand.
But
Yes, so
we have to set for trial. It's just too old. I can't, if they're waiting on us and we're waiting on them, ain't nothing gonna happen. And so our, it's 265 days old. So he needs to either accept the plea bargain or let's set for trial.
yes, sir. He's not here today. He was upstairs. I don't think they brought him.
So
back.
roll it to tomorrow, the next day, whatever you want.
Yes, sir.
Yeah,
Thank you.
okay, thanks.
It's fine.
Great. I'll sign it for you now.
Thank you.
Yes, ma'am. Kendra, what's up?
I'm here with Flavio Castro.
Okay,
I just want to get the next sort of, we're going to do the whole driver license thing.
okay. Yeah, just write it up. But I'm about to bring a jury in, so we need to hurry up. Hey,
Judge Adam, please, you're ready.
I'm ready. Let's do it. Are you Taylor?
Mr. Taylor.
Ms. Taylor, come up. Ms.
Matt Taylor. Hey, come on. How are you, Judge?
What's up, bud?
Just hanging out.
I'm gonna have a jury that's very mad at us. Because they've been waiting outside for a long time.
Thank you, Judge.
Of course. Mr. Taylor, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. The agreement that you have worked out is a 10-month deferred. This is a time for probation that if you complete successfully, there's no conviction on your record, but it does not get dismissed. There's a big difference between the two. There's also an affirmative finding of family violence that attaches to this as well, even if you complete it successfully, which means that you ever pick up another one of these assault cases like this, you'll be looking at a third-degree felony up to 10 years in prison. And you don't have to be dragged down, beat the hell out of someone. Just grab an arm and squeeze enough to where it hurts, and you're looking potentially up to 10 years of prison. Do you understand?
Yes, sir.
You are giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. If you complete this successfully, I've already told you what happens. If you violate this agreement, testing positive for illegal drugs, alcohol, not doing your classes on time, having a weapon, picking up a new case, having contact with the complaining witness, all these, I will issue a warrant for your arrest. I'm going to put you back in jail, bring you out. We'll have a hearing to determine if you violated this agreement. If you do, you're looking at up to a year in jail. Do you understand?
Yes, sir.
Is this what you want to do?
Yes, sir.
For you to complete this successfully, you must do a 10-hour anger management class, 12 hours of community service, no drugs, alcohol, weapons, And does the complaining witness want contact?
This is for.
Mr. Taylor?
I'm confirming the Your Honor. Based on my conversation with her, Your Honor, she wanted some type of supervision. There was no specific,
Until I know that she wants to have contact with you, I'm ordering no contact, okay? I don't know, and so I'm not gonna take anyone's word for it. I don't know.
She contacted me.
Okay, you're not allowed to have contact with her. Just listen, I'll explain it to you. If she reaches out to you, you cannot have contact with her. If she calls you, hang up the phone. If she calls you from an unknown number, hang up the phone. If she texts you, do not reply. If she comes to your house, do not answer the door. You're the one that's going to end up back in custody if you violate this agreement. If you understand, everything can be modified, but I need to know what she wants, and I'm not taking anything for granted. I'm not taking anybody's word for it. At some point, if there's time today, we can have them reach out to see, but really, just don't violate this agreement. Do you understand? How do you plead to this offense? Guilty or not guilty? I'm not going to find you guilty. I will withhold that for 10 months. What do you do for a living, Mr. Taylor?
At the moment, I am a full-time student at Tulsa Law.
Okay, great. That's a great career. And if you make it work for you, underwater welders make $150,000 a year, man. Really, you can just kill it if you do well, be honest. When people see these types of things on a record, you think they're going to want to hire you? Right, because they know that you're a ticking time bomb. You get upset, what the hell's going to happen? So make it work so that you don't end up in an even worse spot. You understand? Waive his fee. All right, good luck, Mr. Taylor.
Thank you, Judge.
All right, thanks, Mr. Hey, are you, Victoria, I'm going to bring up the,
Your arraignment?
are you ready?
We're ready, yeah.
Let me do this plea real quick and then I'll bring it. Would you mind bringing your client up, Mr. Robinson? Mr. White, come up, or Miss White. Are you, Mr. Robinson? Are you appointed or retained on this case?
Sorry.
Are you appointed or
I'm
retained?
appointed, John.
Okay. Ms. White, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. The agreement that you have worked out is a 1-year deferred. This is a type of probation that if you complete successfully, there's no conviction, but it does not get dismissed. You cannot tell people it gets dismissed if you complete it successfully. There's a big difference. Do you understand?
Yes, sir.
You are giving up the right to a trial, right to compel witnesses to testify on behalf, confronting, cross-examining your accusers if you're not a citizen. There are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So was she in the PTI program?
She never entered. She actually gone forward when we were preparing to turn into package. She was originally offered PTI.
This case is nearly 1,000 days old and we're doing a deferred?
Yes.
Where have you been for the last 4 years?
I was taking.
You know what? I just don't care. I don't care. But this is a huge reward for you. And I want you to understand that if you violate this agreement, you are looking at 180 days. I don't know why you're smiling. It's not a happy thing. You had the ability to get this thing dismissed. And because of your taking off, you now will, if you complete this successfully, people will still be able to see it and it will be held perhaps against you. You understand? If you take off on me again, don't do it again. Test positive. You test positive for any alcohol or illegal drugs, I will issue a warrant for your arrest. They will file a motion to revoke and you're looking at 180 days. Do you understand?
Yes, sir.
For you to complete this successfully, you must do a DWI education class. Does she have any prior criminal history, please?
Looking at it right now, Your Honor.
One victim impact panel. You must also do a TRAS to see what are the conditions you need. If they assess other conditions, you must fulfill them. You must maintain a guardian interlock. no drugs, alcohol, 24 hours of community service. And does she have a license to drive?
Running her license right now, Your Honor, she does have a prior attempted assault with public service in 2018, but no, DWI history, and her license is eligible.
Okay, how do you plead to this offense? Guilty or not guilty?
Guilty.
I'm not going to find you guilty. I will withhold that for 1 year. Before she drives, we need proof that she has financial responsibility.
Yes.
So you are not allowed to drive unless you show us that you have financial responsibility. I want to make sure that you have car insurance before you drive. So at this point, I'm ordering you not to drive until you show us that you have financial responsibility. Do you understand?
Yes, sir.
Okay. All right. Good luck. We'll have you see the clerk. Thanks, Mr. Robinson. Okay, guys, who's next?
Just want to approach on the motion that is in the queue. It's for Latte Shine, the motion to sub.
On Shine?
Yes, sir.
Okay, I'll sign it for you.
Thank you.
You got it. Okay, guys, ready?
Good morning, Your Honor. May I approach?
Hey, guys, did you guys agree on a bond?
The state is, saying that 5,000.
The state's gonna argue for $5,000.
That's going to argue for 2,000.
Okay. We'll split it. We'll split the baby.
Thank you.
Yeah, no, I have to admonish them. I can't, I have to admonish her so that she knows in the event that she takes off, there are serious consequences. Yeah, oh yeah, it's a fugitive case, yeah. What's the last name again? Good morning, Ms. Hubbard.
Hi.
How's jail?
Not fun.
That makes me very happy. It's not supposed to be
It's not
fun.
supposed to be.
Right.
Exactly.
And when you continue to pick up cases and when you have cases from out of state, it just gets so much worse.
Yeah, and it's like, I do not.
Just really,
Yeah.
at some point, DAs, they start looking your criminal history. They start looking at everything. Well, this person just don't get it. Let's make the bond high. Let's start tacking on more conditions. You understand? You're wanted out of the state of Louisiana. Your lawyer is asking for me to set you a bond. I will set you a bond, but I want you to understand we don't play games and I'm not going to do this again. I set you a bond one time. We give you 14 days from the date of your release to go turn yourself into Louisiana, right?
Yes.
Which parish?
East Baton Rouge Parish for.
East Baton Rouge Parish. If you fail to turn yourself in with that time, understand there are serious consequences. I will set your bond at 0. I will not get you another one and you can't run forever. We will get you. And next time I'm going to hold you until Louisiana comes and gets you. Do you understand?
Yes.
So do not wait till the last second to go. I would go as soon as you get. The only other thing I'm going to say is that you have 2 open cases in Harris County. You need to stay in contact with Ms. Longmiles because in the event that they take you into custody over there and then they revoke the bonds over here in Harris County, the situation that you're in now will be in the exact reverse over there. You understand?
Yes, sir.
Okay, so what are we setting it at? Do you know? You wanted 5, you wanted 2? Okay, so we'll just,
25?
yeah.
She needs to sign this before she goes.
All right. Do you understand what's expected of you?
Yes, sir.
Okay, good luck, man.
Thank you.
So
3,500.
3,500, yeah.
Thank you, Your
And
Honor.
that is on Hubbard. Okay, all right. Good luck, Ms. Longmire. Yep.
Page 12, McCarter. First initial A, Judge Johnson.
Yeah, I'm going to modify his conditions of homeboys on deferred for a very serious case. Mr. McCarter, you are charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Is it the same facts as in the other
Yes,
case?
Your Honor, they are-
Okay. Mr. Mr. McCarter, I have already found probable cause to go forward in your brother's case. I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you were ordered not to consume alcohol or illegal drugs, and you will be randomly tested. And I'm telling you now, you're going to get tested. It's not a matter of if, it's when. And I'm going to give you a sufficient amount of time. At 50 days, you will be tested. If you test positive for anything illegal, it may not go well between us. You understand? How are you supporting yourself now? I want proof. I'm not going to take your word for it. As a condition, you must work either full-time or be in school full-time. Do you understand? Okay. The other condition that you have is no contact with the co-defendant in this case. You are not allowed to hang out with him. You are not allowed to have any contact with him. Do you understand? Okay. Do you mind appointing him a lawyer? So he's not on docket today? Okay. And you are not allowed to go back to HB as well. You understand? All right, just go ahead, take a seat. We're gonna have you sign a reset. Take a seat. Do not leave until they excuse you. So, no, but hey, I want to modify his conditions, put a GPS monitor, 7 to 7 curfew for now. Okay. Justin. Hey, I'm about to pull a jury in. You want to talk real quick?
We can, I'm just talking with the state.
Yeah, talk to me. They've been waiting a long time, like an hour, so I got to bring them in.
Miss Deborah Michael is still in custody. She did the evaluation yesterday.
Okay.
Talking to her sister. Her sister said she can come home and live with her.
She's her sister what?
So she can live with her. It's gonna take some time to get that report back. And she's followed your bond conditions. I know she got the trust.
She's not followed my bond conditions. Our bond, I shouldn't say mine, our bond conditions.
You get an ankle monitor for her to stay away from the taco place. She stayed away from that. She was at another place. She had an argument with somebody and she went for a walk to cool down. And this cop saw her sitting outside of like a CVS and arrested her outside of a CVS.
Was she not supposed to be at the CVS?
They said that she previously been told but all the warning is like the same day as the arrest, like 6/26. But again, she is somebody who I maintain has capacity issues. And I don't know that she even has mental health issues. She has mental capacity issues. I don't know why we're putting her in the jail. She has not ever hurt anybody. She is.
So in the last year, she's picked up 1, 2, 3, 4, 5. So within a matter of a year, she's on case number 6. Some of those have been dangerous cases as well.
She has not harmed anybody. And the instances that are before the court right now, and the state has not ripped, they have for months been holding her and they have not completed rips on basic terroristic threat cases. They've indicated to me that they are going to dismiss these based on the report that comes back.
I've never said it.
Yeah, you did. But I'm not done. But the fact remains that the state agrees that she's got mental health issues at the very best, and at worst, she's got mental capacity issues. Where she is right now is not good for her or for anyone. Her sister, who knows her, who has been providing for her whole life, has a place for her to live. She's been finding a new apartment where she'll have her own bedroom in that apartment, but she needs her out. They've been waiting to get her social security disability checks. She has a place to be. She does not need to be a ward of the state and in a dangerous place as a vulnerable person.
State, what do you think?
Your Honor, I never said I would dismiss these cases depending on the competency report that came back. That is not how our procedure works. Our procedure works that the mental health was involved in this case because the counsel had questions about competency, separate from the questions he had about understanding the defendant based on her native language, which I understand had been an issue prior to the competency report being filed. I share your concerns, Your Honor, about the danger to society based on this defendant. In this case, the January 14th case, not the June case that she picked up while on bond for the January cases. Defendant is alleged to have thrown a rock at complainant, threatened to throw another rock at the second complainant.
What is that?
Yes, that's the terroristic threat.
Oh, right.
The rocks are described as larger than softball size. All of her previous cases in 2025 also involved her throwing a large rock at random citizens. Case 7/25/25, officer responded to defendant threatening individuals with rocks. Observed defendant sitting outside front entrance of gas station, multiple baseball-sized rocks next to her and one in her hands. Complainant reported defendant is always harassing customers, that he has to lock the doors to prevent her from coming in. And today she was threatening customers with rocks. February 11th, 2025, complainant, 67 years old, was going inside her residence when defendant threw a rock that struck complainant in the head, causing pain and dizziness. Complainant turned around and observed defendant with a rock in her hand. Did not know her personally, just recognized her as a neighbor from the apartments. I do agree that there is some mental health issue going on here, whether it be IDD, a mental health diagnosis. I don't know, which is why we have requested the competency evaluation. Defense informed me that that evaluation was completed yesterday, Justin?
Yes.
Yes, it's my experience that it takes typically between 2 days and a week for a report to come back, and the report is what I am requesting so that we can determine how to appropriately handle Ms. Gabriel Michael's mental health issues so that this doesn't become a problem anymore for her or anyone else. I cannot make those things go faster. We have already expedited that competency report. It came back in, I think we requested it on the 30th, am I wrong? I believe it was the 30th that we requested it, and typically those take a month, but due to the due diligence on both sides here, that is getting done as quickly as possible because I share the concerns that defense does about Ms. Gabriel Michael getting the proper care that she needs. However, it doesn't remove that she's a danger.
She's getting no treatment whatsoever in the jail where she is right now. Her sister, where she is a healthcare provider. And her sister has connections to all of her doctors, everyone that she's seen in the past, has access to her medical records and is trying to get her social security. Her sister's where she needs to be. The state's not giving the court any reason why she should stay in jail. They've given you the background and the history about the case of the person who got hit with the rock. That case is not before this court. That case is over. I don't know if y'all dismissed it or if she pled out on it, but she's done. The terrorist threat that's pending before the court is one where there's an allegation of throwing a rock in the direction of the person, not at the person. They didn't charge her with assault. That would be assault. That's what I argued in the PC on the beginning of that case. But Judge, since that January incident, she's followed your rules. There was that one time, if you remember, when she was found to be within the 1,000-foot zone. But when you looked, it was like 20 feet in, and it was waved, and she drove by and you let her back.
Didn't we order her not to be loitering and do the same types of things that have been in the past?
Okay, so that day, she needed to take a walk, and so she went and took a walk, and if you look at the dim summary, it's like June 26th or 27th, they're like, say, that on that day of the offense is the day that she got the trespass warning. She's just trying to walk around and like cool off a little bit and calm down, and she's just sitting outside by herself. She's not going in the store harassing anybody that we can tell, and they charge her.
I don't know.
I honestly think that the police, when they got there, with her inability to communicate, with her capacity issues, I think that they were just like, let me just take her in on a hot day. And if I made a mistake, the court and the DA will fix that. But they were just trying to get her off the street that day. But she doesn't need to stay where she is right now, like at all. And she has a place she can go. She's followed your rules.
When are we gonna get the results? Because I think I'd like to base. I'd like to look at the results first before I just start giving.
What we're doing is like, we're holding her on just to see it. I don't think that's a reason why the taxpayer should be paying for somebody in the jail while they have a place to go. And I don't think that's good for someone who's got these issues going on. She's in a dangerous place for someone who's vulnerable like her. And the state wants to keep her there just to see what the paper on the report comes back on. I don't think that's a good reason to incarcerate someone.
Let me be clear, the state wants to keep her there because I believe that she may be a danger to others based on what I'm seeing in my case file and my pending cases.
So you should file a motion to revoke the bonds that are in place right now.
I believe the
Raise them all
bonds are
to a
sufficient.
amount. If you think that they're sufficient, then she does not need to be in.
Okay, well, regardless,
She can't afford the
I don't know, Justin, but all I know is
That's my
that.
point, is since we don't know, if the default should be freedom. And when you don't have something like, I'm compelled to keep her in, I know to keep her in, then you should default to, let's set terms and conditions for her release, and let's let her.
I'll give you a chance, don't worry.
That's all I'm asking is, she's followed your reasonable terms and conditions for bond in the past, and she hasn't hurt anybody. She hasn't picked up any rocks. She hasn't thrown any rocks in the direction of anybody. Because you have put her on an ankle monitor and with bond conditions, and she's followed them.
But we've put all these devices on her. I mean, I really have nothing left at my disposal to ensure that she doesn't pick up a new case. I mean,
But Judge, it's a trespass sitting outside on the ground. I think it's a CVS or Walgreens or something, but I mean, it's like the least egregious kind of thing possible. And the state that they said that they gave her the warning is the same.
Right.
Thing happened.
but in,
When you're mentally retarded, you don't speak the language, you don't have like anything but a sofa to sleep on, you just need a little bit of, sometimes things get a little bit frustrating for you, and you need to just be able to walk around and blow off some steam. That officer wasn't giving her a chance that day. She just needed to be like left alone, and we'll litigate that case, but she's presumed innocent of that offense, just like the two terroristic threats that are here. And
I don't know.
I don't know why we need to leave her locked up, someone who's got capacity issues. She is a danger over there. When somebody starts to figure out what's going on with her, they're gonna take advantage of her. She doesn't understand what the inmates say to her.
You know, I will say that I am not going to just let her out in hopes that she does something and gets some kind of treatment but if you can show me some kind of plan that when she gets out, she will address any kind of issue so that we know that she is being proactive about not either picking up a new case, dealing with any kind of anger issues, with any, so that we know that nothing further happens. But you told me, you told me just 2 seconds ago, well, when she was out, she was working on this plan and she was working with the family and they were getting this kind of treatment and, you know.
Her sister has all that, and I got that from the court before when we were trying to get her out the first time. So let me go back with Mesa and I can get that.
If you show me that you have a proactive plan to where if we let her out, she's just not gonna get out and do the same thing because, I mean, really,
Her sister believes that she needs her own bedroom, so that when she has these times.
I'm talking more than that, though.
Well, I know, but there are some things that are just so basic that we all take for granted. We have our own space in our own homes. She doesn't have, she has a sofa in a place that she shares with kids and her sister. So her sister's like, I'm trying to find a 3-bedroom apartment. The kids can have a room, I can have a room, my sister can have a room. I was like, do you think that will change a lot? She's like, yes, if she has a room she can go into, you close the door and like put on her headphones, it will make all the world of a difference. So she's like, I need to get some time to get that apartment. So let me see where she is with that. I can come back in. But that's the plan that the family has in place. Her sister's like, I need her back.
I am not opposed to a PR bond, but I'm not going to do it with the hopes that things get better without some kind of plan
Sure,
in
and then the
place.
GPS monitor to.
That's not sufficient. We had a GPS monitor, she picked up a trespass. It's not sufficient.
But she picked up a trespass and it was a brand new place.
Great.
She's trying to find her way in this world.
Work out the 3-bedroom apartment.
Okay.
In addition to that, I want to see more than that, whether it's, you know, anger management, whether it's talking to some counselor, whether resources through the PDO's office, you know, but you've got a social worker, get the social worker, start working to see.
Connected with the Max social worker,
Yeah.
that's already, that relationship is there.
Great.
But they're not gonna provide her language services for taking a class or doing those things like that. They only provide me language services to communicate with her. So I can do
Okay.
that. but there's just not-
Go ahead.
My offers regarding disposition have always been to create an appropriate being the keyword, discharge into the community plan for.
So
her.
let's get cooking. Great. I'm
Yes,
with
that
you.
is. I'm
Get
on the same
cooking.
page.
And let's see if we can work it together all at the same time.
Yes, yes, Your Honor, I agree. with
I'm
that.
willing to roll it tomorrow, the next day, whatever you want.
Tomorrow will be great.
Yeah. I don't know if that's
I
enough
don't
time
know
for
that
them.
Competency.
No.
I don't know if it's enough time for them to create something that you guys can both agree on that.
I'm gonna carry her day to day because I don't want her just left over in the jail. And at least when she's
You
over
should
here.
understand, she gets up at 3 a.m. to get here.
I know.
So
But
I know maybe
when she is
he's
with
on
stuff,
you, but
this is a little bit better for her than just being left over there where she, I mean, like, hold on, she's more.
I mean, if that's what you want, that's what you want.
And I wanted to address what you were saying about her not getting any medication in the jail. Are you of the understanding that she's not receiving it? Okay, because on the warrant sheet, I do have milligrams. If you have information that says that that is not the appropriate medication for her,
No, I'm not gonna go to that.
you said you have
You're
that
the
medical
state, you know better than
documentation.
I do about people's lives. So I'll let you.
Don't get passive aggressive, man. Really, there's
I'm
just
trying-
no
I'm
need.
good. I'm good, Judge.
Please.
We'll go talk to Tracy.
All right. Okay.
Well, it's just
Thanks.
every day in paradise.
All right. Hey, guys, you ready? Come on. Let's cook. Hi, Sina. Hi, Eddie. What's up? Give me a last name.
Dinesh, DANES.
That's right. All right. Do you mind bringing out Dinesh, please? Did you guys, so what say you?
He already waived on the sixth judge and they're approaching to potentially withdraw the waiver, losing his credit to approach the potential bond. This doesn't carry the death penalty or life in prison, so he is statutory eligible once he withdraws. He's wanted for 4 charges. Well, wait until you.
Are you okay or no? You're opposed? What's that?
I know you said that, you asked me how Fort Bend was, I just came from Fort Bend. How's Charlotte going?
Yeah, exactly. The jury's been out for like an hour and a half now. I mean, they're gonna be so upset. Oh my God.
Sorry, it's only.
No. Let's get it done so we don't have to bring it back and forth and back and forth. Just, and you guys don't have to wait too.
Do you have like a family argue, or is it like one of those things where regardless of the argument, you're not gonna get a bond here?
I grant bonds all the time. I want to know whether they're dangerous or not, whether they're a flight risk. So. Good morning, Mr. Dinesh. Come on up. So, good morning. So your lawyers are asking for me to set you a bond. I don't know. I've never met you before. I don't know you, and I have a very short amount of time to get to know you to see. Two things are important. Number one, if we set you a bond, are you going to go back? Number two, will you leave a wake of destruction on your way back? Those are two things that we don't want. So we try to get to know your fast to see if we should or not.
And he's wanted out of Escambia County in Florida. He's wanted for 4 charges. He's wanted for impersonating misrepresenting personal identification, grand theft, 5 to 10K, and using a two-way communication device to facilitate a felony, and obtaining property over $5,000 by, I'm not sure if it's fraud, it just kind of figures out, but cash professional. The accusation here is that he impersonated a sergeant in Pensacola PD to scam a complainant to transfer $7,000 of Bitcoin. They use a grand jury subpoena to identify and link this defendant. Due to sophistication impersonating a peace officer is that the state would be opposed to a bond. Pensacola has requested that this court impose a no bond as well. They already stated they facilitated the extradition and they would be here by the 16th, which is well within the 15 days granted by this court.
So they'll be here when?
They'll be here by the 16th, but the reset will be the 21st.
16th, so.
But right now, he's not even eligible to get a bond unless he withdraws his waiver and loses his credits.
So, Your Honor, first of all, like, I think the state doesn't even know what the allegations are, you just know the charges. But the fact is that I know this young man and his family, he's one of the most successful jewelers in Houston that I know of, and he's well known. He has no idea what this is about, and we don't either. He was going to Aruba, was it Aruba? Bahamas on Thursday, I think it was. At the airport, he gets picked up. He's never been even like on notice of this. No criminal history. I mean, his family and what I know of him, they're the most polite, generous, and intelligent people I know. So, and they're just in shock.
Does he have any criminal history?
None.
How old is he?
19. Right.
Does he have any criminal history?
He doesn't have any criminal history, but as the court knows under Michigan v. Doran, the underlying charges are relevant for the extradition other than.
I know. I get it, but you know, it's not capital murder. We have a lot of people in the jail, really. I'm okay with setting you a bond, but I want the passport first. So I want to make sure that he's not going to take flight, but.
Whatever you need, Your Honor, I mean, I'll make sure, and I know him, his family and everything.
An amount?
I'm sorry?
An amount?
No, Judge, I'm standing on the no bond. He impersonated a sergeant for peace officer, stamp $7,000.
Well, and so at some point, he'll go back. Florida will do what Florida does and but here.
No, I disagree, Your Honor. You're assuming that he's going to go back. There's plenty of people who said they were going to go back, and there are a long list of arrest warrants for people who have not actually self-served.
Hold on, but Your Honor, as officer of the court, he's never been.
I don't care. Sina, I'm going to set you bond, really. So give me the passport first.
Okay.
If he takes off, I've got his passport, really.
Then to be eligible for the bond, state
So-
requests that he sign the waiver of struggle with his credits.
Yeah. So understand, a lot of people would rather wait for whatever demanding jurisdiction is going to come get them, get a free ride back, using all that, instead of paying to get out, use that money hiring yourself a lawyer in Florida, but you do what you want to do. They've already indicated that they'll be here within the next, 6 days to come get you? 6?
10, 9 days.
About give or take, right? So if you want me to set you a bond, you have to withdraw the waiver that you've done, all the credit that you've earned now, because if they don't come get you within 14 days, Harris County releases you. If you want me to set you a bond, you have to withdraw that waiver and you will lose all that credit. So.
Oh, and I don't think I shared it with, this isn't like a criminal case. The number isn't 10%. We can't do 10% of the bond. When I ask for like, for example, 50,000, it's the full 50,000. It's not 10%.
So that's something else to consider.
What do
So
we, potentially, what would the bond be?
I don't know. I mean,
Like I said, I don't know, whatever the court decides to set, the court decides to set, but I'm at no bond. The impersonator sergeant, I'm at no bond.
I mean, you don't know.
I've already explained for the purpose of the uniform.
I mean, typically in these types of cases, we set them around, 5,000 to 10,000, give or take, whatever it may be.
And you'll
So
get that money back once it's all said and done, right?
I don't
I'll
know.
look into it.
I don't know.
Let me get the
But
passport lined up.
so first of all, get the passport, I'll set the bond at $6,000.
Thank you.
Okay?
All right, thank you so much.
Understand though, we only give you 14 days from the date of your release to go turn yourself in. I have enough drama in my life. I don't need any more. I'm not gonna do this again. You get one opportunity. If you fail to go turn yourself in, I will revoke the bond. Whoever ponies up that money is gonna lose it. I will set the bond at 0 and I will not give you another one. Do you understand? The only other thing I'm gonna advise you, as Murphy's Law dictates, what can happen will happen. So if you try to wait till the second to last day to go over there and you say, oh, damn, my tire blew. I don't care. I have enough drama in my life. You understand, Mr. Dinesh?
Last thing, George, the 4 cases, 3 have bonds, 1 doesn't. So even if he gets his bond today or tomorrow, I don't think he can be released because of the Florida hold here. Right, so.
He's referring to the bonds in Florida, which is irrelevant if the fugitive case.
Yeah, so understand, we set a bond here and now.
Right.
He'll pay the bond, he'll get released. You always have those warrants in Florida. You could literally get pulled over,
Right. So there's
or
not.
whatever it may be, and they can take you right back in.
I thought there was a hold still.
There is, in Florida.
Okay, you don't want to affect this. Okay.
So we will let him out, but
Gotcha.
those warrants in Florida will
He'll go
remain in
straight-
effect and will always be until he goes back there and turns
Just
himself
take the
in.
car straight over. Thank you.
Because we had one where they left Harris County, got a bond, and they got arrested in Montgomery County.
No, I get it. Get out of your way.
Yeah.
Thank you so much.
Yeah,
for,
yeah, okay. So I'm not gonna set it yet. Get the passport, put it in here. We'll take it in the registry. I'll make a docket notation. At that point, we'll set the bond, but he also has to do a waiver withdrawal.
Yes, thank you.
Okay. All right. Herman, real quick.
Judge, you gave a guy second till yesterday to get his interlock. He doesn't have an appointment until Wednesday.
I don't know. Just do the bond violation and we'll do it then. I mean, we have rules for a reason. If you wait till the last second, that's on you, man. So we'll have to deal with it when we deal with it. All right. All right, I'm gonna bring the jury in. I mean, really. Hey, are you ready? All right. Hey, so, State, Cameron, thanks for coming in, man. Don't get into HGN. Are you ready, Ramona? Hey, all right, guys, we are going on the record. Please do not talk. So for purposes of the record, I've granted the defense's motion on the HGN not to get into it. Please, State, do not get into it. And we're still, the ball's in their court still.
Yes.
Yeah.
There are 2 witnesses in the witness room. Can I request that they please be sworn in and placed under the rule?
Yeah. Do you mind going and grab the 2 witnesses?
Judge, top of 17. That's what Darla's looking for.
Darla, what's going on with your case?
Yes, Judge, this is the PTI that we had the contract about a week ago, and then you reset it to this week. I thought we'd be able to have everything in. However, my client asked if she could
Hold on, Darla.
Okay.
Okay, tell me, did you guys take care of what you need to get did she get it done?
So she is asking for a little bit more time to finish working on everything.
Your case is 220 days old, Darla. I'm not giving you guys any more time. You've literally had over and over and over.
No, Judge, we had 1 week and I thought that would be plenty of time, but from the time we got the contract to today's date, it's been 1 week.
You received the contract nearly 2 weeks ago on the 25th.
Let me double check.
So that's not right.
So I'm sorry. The courthouse was closed on the 3rd. We've had a week and 2 days.
Okay, I'll give you a week. At that point, if it's not done, I'm rolling you day for day.
Okay, I understand.
Exactly a week from today.
Thank
All
you,
right.
Judge.
All right, witnesses coming up, please. Both of you solemnly swear to tell the truth, the whole truth, and nothing but the truth. Okay, you guys have been sworn in for purposes of the trial. Also, the rule has been invoked, so please do not talk to each other or do not talk to other people about this case. Okay? All right, just we're trying to get to it as fast as we can. I know. I'm sorry. Guys, if you want to. And thank you.
Based on your ruling on the HGN, I'd like to request that whole video portion be redacted, not just muted, because it will still show the administration.
Yeah, yeah. Yeah, because otherwise they're going to wonder what's going on there. You know what I mean? So just from the point where it starts to where it ends, at that point, it'll be redacted just for purposes of the HDN.
Can I just jump into it? Because
No. It's been, don't mention it, please.
No, I won't mention it, but if I have to redact it, it will take some time again. I have to go downstairs and.
I know, and we'll have to get that done, but we'll deal with it when we get there. Before the jury gets it, we'll send it down to get done.
So Judge, but then we don't have any testimony now before that. It's just a stuff.
No, but there are other things that you can get into. There are other field sobriety tests, no?
Just a walk and turn, but then we will have to do the video at that point.
Well, we'll have to cut and.
Yeah.
So what I had envisioned is you play the video up to the part where the HDN begins, then we'll stop it, forward it to where all the rest, right after it gets done, and then you can continue to play it at that point. Just that part is not played, because it'll just confuse. Yeah.
I misunderstood. I thought you were saying redacted now and then.
No,
Okay.
no, God, that'll take another, no. All right, let's go. No, God, no,
Yeah,
please, for the love of Pete. We'll wait another 2 hours.
The video is that maybe.
Yes, subject to the redaction. And subject to, I think he also wanted to make another, Tyler, were you making another, Tyler?
I'm just thinking, I don't think that I have a motion to suppress or any other objections on Corporal Ryan's on this video.
Got it. Okay, cool. So it'll be admitted states 1. Yeah.
All right, for the jury.
All right, guys, please be seated. Please be seated. You know, as I told you, as being in court here, imagine you have children at home, right? And the children keep saying, come on, I need this. Come on, I need. So we have a lot of housekeeping and I'm trying to get to you. And then someone will go, there's somebody. So I'm so sorry. We're back now. Let's get started, please.
Sergeant Ryan, I'm going to show you, part of State Exhibit 1. And, I want you to tell me exactly what you see here. Hey, could you tell us what, you saw, or tell the jury what you saw there?
That is my body camera from in my car prior to, and then as I initiate the traffic stop.
Were you able to determine, the defendant's speed at that?
I was.
And what was the highest speed that he was going?
The highest speed I got was 85 miles an hour.
So at this point, you have conducted the stop, correct? And you're about to approach the car. What did you notice first when you approached the car?
When I approached the vehicle itself, upon making contact with him at the vehicle, I observed the odor of an alcoholic beverage coming from within the vehicle. I also noticed that the driver had red bloodshot eyes.
Did you see or hear anything else that prompted you into conducting a DWI investigation?
During our conversation, the driver did admit to me that he had just came from his parents' house, and while he was there, he had consumed 6 beers.
Did he tell you around what time did he have the alcohol?
I don't recall.
And as you can see the timestamp, can you tell us what time it was?
4:01 a.m.
Okay, I'm gonna show you that interaction and show the jury that interaction.
Insurance. Guaranteed speed, and I'm gonna make you find 6,000 measurements there. What's on your registration on the vehicle? Where you come from? Just came from, right, so we all doing over there. Drinking, how much are you drinking? Okay, what time you start drinking? What time you stop drinking? Around midnight. We just got a 6 packs. We'll see. You just like a. Okay, you just get okay?
So did you notice anything different from what you just told us you heard? From where he said he was coming from?
No, it sounded like parents' house.
Okay, so what did you hear now?
It sounded like friend's house. Listen back to it.
Why do you think that you heard it wrong?
His speech was a little slurred, a little mumbly.
So what did you do after this?
I went back to my vehicle, called for another unit, and ran his information.
Can you tell us about, did you conduct a field sobriety test at that point?
After I ran all this information and called for another unit, I began the field sobriety test.
Let's talk about the 2 field sobriety tests. that you conducted. What was the first one?
The walk and turn,
And, what's the second one called?
the one leg stand.
Okay, so let's go, over each one. Do these tests accurately or help you determine loss of mental and physical faculties?
They do help, yes.
And, can you tell us about the walk and turn test?
What specifically?
So, the steps.
So you get them into the instruction phase, so you get them into their stance, tell them to stay like that until you explain the totality of the test. You go through and explain the test, also demonstrate the test, and then have them conducted.
And in this case, did you explain the test?
I did,
Did you demonstrate?
I did.
Um. I'm gonna go ahead and show you, I wanna show you the walk and turn test. And I want you to, help us through the clues that you see. So let's talk about the clues before we do that. What clues would you say on walk and turn would indicate somebody, being intoxicated?
So there is 8 clues in total that can be, typically over 2 clues would be your decision point to show possible intoxication.
I'm gonna object, that's not responsive to the question that state asked. Should what clues answer numbers?
No problem. Okay.
So, can you tell us about the clues that you're looking for in walk and turn?
You would have, start too soon, struggle with standing during the instructions, stepping off the line, missing heel to toe, improper number of steps, improper turn, and utilizing arms for balance.
So let's go ahead and watch that walk and turn.
Want you to imagine a straight line going that way, okay? Okay, now? Yep, just imagine a straight line, okay? Don't stay where you're at. So that's what I'm saying. I want you to take your left foot, put that line, foot on the line, okay? Take your right foot, heel touching toe, put it in front. Just do it like I'm doing now. So left foot on the line. There you go. Heel touch, stop right there. Hand by your side. Stay like that until I tell you to move. Okay? When I tell you to begin, I want you to take a series of 9 heel toe step down line. Leave that lead leg on the ground. Take a series of small steps. And you take 9 more heel toe steps back down the line. Okay? It's gonna look like this. 1, 2, 3, so on and so forth. Till you get to 9. Leave that lead leg on the ground. Take a series of small steps. You can take 9 more down. 1, 2, 3, all the way till you get to 9. Okay? I want you to count out loud. I want you to look down your feet. I want you to keep your hands by your side. I want you to keep going until you complete all your steps. You understand the instructions I'm about to explain them?
A quick question. So, you say, don't say one,
So 9 down, right? 1, 2, 3, all the way till you get to 9. Leaving that lead leg on the ground, you're gonna take a series of small steps. And 9 more and back down. 1, 2, 3, all the way till you get to 9. All right? So, any questions? Okay, you may begin. Just 1, right? You can take your first step. 1, 2, 3, 4, 5, 6, 7, 8, 9. Clear, right? Just I explained it. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10.
If you can explain to us, what clues did you see in that test?
He struggled with balance during the instruction. He had the wrong number of steps, did an improper turn. He missed his heel to toe, as well as he stepped off the line.
When he, when you were explaining to him, he saw you explaining it twice and demonstrating twice. Did he at any point ask you or tell you that he didn't understand English, that you didn't see here at any point during that stop?
No.
What is the next test?
The one like stand.
Can you tell us the clues that you're looking for in the one next stand test?
To see if they put their foot down, if they sway, if they hop, or if they use their arms for balance.
And if you can explain to us also, I should have started with that. How is the one next stand done?
Very similar where you get them in their stance, you have them stay just as they are until you can explain the test. I also demonstrate it prior to and then have them complete it.
And if you can do me a favor, just slow down a little bit when you're talking, so she can.
Sorry.
Okay. Okay, so what clues did you, actually, let me show you and then you can tell us the clues that you saw.
Alright. That's how he's there, dude. Okay. Keep together hands by your side, okay? When I tell you to begin, with the leg of your choice, put it straight out, getting your foot 6 inches off the ground, keeping that foot parallel with the ground. And keep your hands by the side, look down your foot, you're gonna count aloud. 1001, 1002, 1003, so on and so forth until they tell you to stop. Okay? Keep your hands by your side, make sure you're looking down your feet, make sure you keep that leg straight. That foot 6 inches off the ground, and count aloud. Do you have any questions about that? Just one question. I got 1,000, 1001, 1002, 1003. You keep going until I tell you stop. Any other questions? Okay. You're gonna begin. 1001, 1002, 1003, 1004, 1005, 1006, 1007, 1008, 1009, 1010. Okay, 11. What is it, 12? What is it, 13? What is it, 13? What is it, 14? What is it, 15? What is it, 15? Come over here, sit on my push button right now.
Okay, so what clues did you observe?
He puts his foot down and he was swaying.
What is what?
Puts his foot down and he was swaying.
What did you notice with the count?
He struggled with counting, miscounted.
Why are these clues important? What do they show you?
With the divided attention test, if they hit certain maximum number of clues, shows possible intoxication over those set of clues. So in this case, 2 with the decision point on it.
So how do you score a one-leg step?
Out of 4 clues, you want a minimum of 2 clues.
And what was what?
His was 2.
What about the walk and turn? I forgot to ask you that. How many clues are you looking for?
At least 2 clues out of 8.
And what was the defendant's score?
5 out of 8.
So based on what you observed, what was your conclusion of your investigation?
I believe he was intoxicated to the point where he lost the use of his mental and physical faculties.
And that conclusion, is that based on your expertise and training?
It is.
And what did you think was the cause of his intoxication?
Alcohol.
And what are you basing that
Based on his own admission of drinking and to the odor of alcoholic beverages from his person.
on? Possibly, Mr. Honor.
Okay. Mr. Flood, are you ready?
Yes, I'm ready. Thank you.
Floor is yours.
So on this video, you stated that the first, well, we didn't see the beginning part of that when you made the stop. We just saw your volume of digital numbers, right?
Can you say that again?
Yeah, we didn't see the video of you following his vehicle.
Correct, just my body camera.
Okay, but we have that video, correct, from your dash cam?
I believe so.
Maybe approach bench.
Sure, briefly.
Since the vehicle was suppressed because it came into it. And now, this has got now 50,000 suppressed. They didn't want about it. Unless the jury show it.
So you're gonna withdraw? Are you gonna withdraw your question? Okay, so I'm gonna tell him to disregard, but you're gonna withdraw the question. Okay, all right.
Thank you.
All right, Mr. Flood, you're going to withdraw the question.
I'll withdraw that question.
Okay, please, ladies and gentlemen of the jury, just disregard that, okay? And we'll continue. Okay.
So I do want to ask you about the stop though, okay? You said, I think you were out, on 45 and you were following this gray truck. Is that right?
I mean, I was patrolling 45, yes, sir.
Okay, and there were other people, speeding, going actually faster than Mr. Cruz, right?
I don't recall if there was.
You don't recall?
Yes, sir.
There's no evidence or proof you have to show the jury that he was weaving, or that you can tell them, right?
No, sir.
That he was, driving at erratic speeds, slamming on his brakes, or any of that, like varying speeds. You don't have any evidence of that, right?
Correct.
So you know what, NHTSA is, NHTSA, right?
Yes, sir.
Stands for National Highway Traffic Safety Administration, right?
Yes, sir.
And they're the authoritative body on the subject of field sobriety testing and how to administer this test, right?
Yes, sir.
And then during your training, you were taught out of a participant manual,
Yes, sir.
and that manual is authoritative also on the subject of field sobriety testing, how to give those things to look for, right?
Yes, sir.
And it talks about 3 phases of DWI detection, right?
Yes, sir.
And can you tell me what those are?
It was the vehicle motion, the personal contact, and I forget the verbiage on the last one.
Pre-arrest screening?
Yes.
Okay. And so the pre-arrest screening is where you would conduct whatever of the 3 field sobriety tests that you conduct. That's where you do those tests, right?
Correct.
Okay, so but before that, there's a phase to observe and talk about anything you notice about the vehicle being in motion, right?
Correct.
Any signs that you observe that might indicate intoxication, correct?
Correct.
And that's what you're here to tell the jury today, about what you might have observed in Mr. Cruz's driving that indicated he was intoxicated, correct?
Can you say it again? Sorry.
That's what you're here to do today, is to tell the jury about any signs of intoxication that you might have observed from his driving.
Yes, sir.
Okay. And the NHTSA manual, there's a litany of types of driving behaviors that could possibly indicate, an intoxicated driver, right?
Correct.
I mean, such as running a stop sign, running a red light, things like that, right?
Correct.
Straddling lines. Right?
Yes, sir.
You didn't witness any of that, correct?
Correct.
The way they turn, if they're drifting, they're almost striking other vehicles. You didn't witness any of that, correct?
Correct.
Okay. Driving in the opposite lane, that didn't occur, right? I mean, like going the wrong way against traffic.
Correct.
Wasn't following anybody too closely, correct?
Correct.
Without going through all of them, I don't know when is the last time you had a refresher
Would be
course?
January of this year.
January of this year.
Yes, sir.
So you know, I have a second NHTSA manual, if you would like to use it to refresh your memory about anything I ask you, okay? I mean, obviously you don't memorize the whole manual, right?
Correct.
But you're aware that it's divided up into different sessions, right?
Correct.
And there's also papers contained in the NHTSA manual. Are you familiar with the paper that talks about the visual detection of DWI motorists?
Could you say it again?
It's a NHTSA paper, talks about the visual detection of DWI motorists.
Yes, sir.
Okay, and in the NHTSA manual, there's a whole page that talks about different clues you could observe about their driving, right?
Correct.
And there's a section called speed and braking problems, right?
Correct.
I don't know when the last time you read this is, but you're aware that speeding actually is not listed as a clue of intoxication.
Correct.
Correct. Okay. So you're not here telling the jury that because he was speeding, that was a sign he was intoxicated.
Correct.
Okay. But that was the only reason that you made the stop.
Yes, sir.
Okay. All right. And then you stated that you observed an odor of an alcoholic beverage
Yes, sir.
and bloodshot eyes.
Correct.
And so we see your body cam walk up to the cab. We don't see Mr. Cruz in your video shot, right?
Correct.
And you talked to him briefly, right?
Yes, sir.
But you're saying in that amount of time, did you lean into his cab and shine a light in his eyes to see that they were bloodshot?
I didn't shine him in his eyes, no.
Okay. Well, we don't see you checking his eyes on the video, is what I'm saying, right? We don't see you checking his eyes on.
I mean, I didn't specifically check him, no. I could see him from the approach.
Okay, and you're sure that you smelled an odor of alcohol coming from, you said inside the vehicle?
Correct.
Okay, so that's different though than saying to the jury, I smelled the odor of alcohol coming from his person, right?
Correct.
So at that point, you're not telling the jury that when you approached him, you're not saying that you smelled alcohol coming off of his breath, right?
From when I approached, no, sir.
You did not.
Correct.
Okay, and you know, the law in Texas is that it's not illegal to drink alcohol and then drive as long as you're not intoxicated, right?
Correct.
A person can drink alcohol and then drive as long as they're not intoxicated. They can't drink and drive at the same time. That's illegal, right?
Correct.
But the odor of alcohol alone, that doesn't tell you how much a person has consumed, right?
Correct.
And just having an odor of alcohol from the vehicle, obviously that doesn't prove that a person's intoxicated, right?
Correct.
Having an odor of alcohol inside the vehicle, that doesn't mean a person is driving while intoxicated, right?
Correct.
It could just mean that person had something to drink, right?
Correct.
It could mean that there's an odor in the car. You don't know who was in there before or what might have been in there, but you can't even really pin it on Mr. Cruz at that point, right?
Correct.
Okay, and so you asked them like, where are you coming from or where have you been, something like that?
Yes, sir.
And I know you said you weren't exactly sure if he said like his friends or his parents.
Correct.
Okay. And then I know that you testified, the state said that he admitted to drinking alcohol, or you said he admitted to drinking beer.
Correct.
On the video clip that we saw, when you were asking him questions, when you stopped, you said like, what were y'all doing? He said drinking. Right?
Correct.
He never said drinking beer. Did he?
I believe you did.
On that part of the video?
I don't recall which part it was. Within the video, yes, sir.
Okay, so I'm talking about, so this is going into the personal contact phase, right? So you make contact with them. I mean, he said, well, if you want, I can play it again so you can hear it, but there's no admission he was drinking alcohol. He just said drinking. You might assume that was alcohol, but he never said that, right?
My recollection is he did say that.
Okay, Your Honor, I'd like to, if I may, publish
Sure.
a portion of states, one. Is that states one?
Yeah.
If you hear it, let me know. Some parts are easier to hear than others, is that right?
For sure, sir.
And while we're doing that, you also hear that he's got an accent, correct?
I didn't notice, sir.
You didn't notice that he has an accent?
No, sir.
Go Brown's council office, do you like your insurance? How many people you speed, and I'm doing 85 and 65 off the main lines there. What's wrong with your registration on this vehicle? Where you come from? State from, alright, tell us, where y'all doing over there? Drinking? How much are you drinking? Okay, what time you start drinking at? It sounded like around.
Okay. I'm stopping at, is it say 1 minute 45 seconds on the media frame? So you asked him about drinking. Did you hear him say that he was drinking beer?
No, it was a reference to the six pack, if I recall.
I'm sorry?
It was a reference to the six pack I was remembering to.
Okay. I got you. So, I mean, in a case like this, where when someone's on trial, we don't want to assume things that we don't know for sure, right?
Correct.
We don't want the jury to speculate about things that we can't prove, right?
Correct.
I mean, I get it. This isn't the biggest part of the whole case, but he said drinking, mentioned a six pack, but it's kind of like an assumption that it was some alcohol, right? But the point is, he never admitted that it was beer, even though he testified to that, right?
Correct. In that portion, yes.
So it's important to tell the jury accurate facts, right?
Correct.
And you actually wrote, you didn't author the main office report in this case, did you?
No.
So you're familiar with the term like primary officer?
Correct.
Were you the primary in this case?
I initiated the stop, but I wasn't the primary officer now.
Okay. You made the stop and then you I think, we get copies of your mobile data terminal communications,
Correct.
and you had asked for can somebody check by, right?
Correct.
And there were actually 3 other deputies that showed up. Do you remember their names? So we know Perez, right?
Correct.
And do you know the other 2 officers' names?
I don't off memory alone.
There were 3 separate constable cars though, right?
I don't recall how many there were. Sounds correct.
Do you know who, deputy? It is relevant to go towards the investigation.
Yeah, overruled.
So you asked for somebody to check by and 3 people checked by. Do you know Deputy Johnson?
Yes, sir.
E. Johnson?
Yes, sir.
Okay, and then Deputy A. Reed, R-E-E-P?
Yes.
Okay, and then is Zachary Ryan? Okay.
That's myself.
He was there
That's
as well.
That's me, sir.
I'm sorry. Deputy Perez.
Correct.
Yes. So in that situation, you were calling for somebody to conduct the field sobriety test?
Just to check by and take over.
Take over.
Correct.
Take over at this point, you assumed it, or had decided it was a DWI investigation?
Correct.
Okay, so you asked someone to check by to take over the DWI investigation.
Correct.
And obviously, part of the DWI investigation is conducting those sobriety tests, right?
Correct.
So out of the 3 vehicles, or 3 other deputies, Deputy Perez, you made contact with him at the scene, right? He came up to you, y'all talked,
Correct.
and I think one of the first things you asked him was, can you do the field?
Objection, can we approach
No, just state your objection.
this?
Oh,
Something that they're stepping over.
Well, I can
Can't have it
rephrase
both
it.
ways.
I mean, okay.
Was your intention to have Deputy Perez do the takeover of the DWI investigation?
Correct.
Okay. And by takeover, is your intention for him to conduct the field sobriety test?
Potentially, yes, sir.
Okay. But through your investigation at the scene, I guess experience is important in your ability to do those tests, right?
Yes, sir.
And I guess you learned or knew that Deputy Perez does know how to do this.
We're stepping over again.
Come up, please. Yeah, you're right. You can't open it. You're gonna open the door and then it's gonna come in. I mean, really, you can't have it with all these. Really? I mean, either yay or nay, but if you can open the door, you can open the door.
Okay. So that's, it's just letting you know.
But you need to open the door or you don't open the door.
I don't think I can secure it.
You know what I mean?
Maybe I could just say he wasn't able to do that.
No, I mean, if you do it, then you're opening the door. Really, it's gonna go. If it happens again, the door's open.
I mean, I can. I'm gonna just.
Either if it happens again, the door's open, really, because
So that.
it's.
Right.
Okay, all right.
Okay, where do we leave off? So nobody took over the DWI investigation. You proceeded to conduct a field sobriety test.
Correct.
And you kept, or I guess Deputy Perez stayed on the scene and you kind of released the other two deputies, right? So y'all can cut off or something like that?
Correct.
Okay. All right, so you stated that, is there was there some reason that stood out in your mind that you, wanted to stop Mr. Cruz's truck when other people were speeding even faster?
Objection, Your Honor, swinging tracks does not prohibit.
Say, what was it? Repeat the question, please.
I was just asking, what was it, was there something that drew your attention to Mr. Cruz's vehicle when there were other people speeding
Overruled.
faster?
Overruled.
You can answer the question.
I don't recall the vehicle speeding. His vehicle is the one that caught my attention.
Okay. All right, so let me ask you about the field sobriety test. And I'm gonna ask you some questions that you learned in training or should have learned from like the NHTSA SFST training, okay?
Yes, sir.
Okay. And if you need to refresh your memory, I can approach and hand you this other copy, all right? So you talked about there being three tests, right?
Correct.
And you're aware that those tests, they've been validated by studies, correct?
Correct.
And that your point in using, I mean, these are like tools you can use to make an arrest decision, right?
Correct.
To determine between an impaired and an unimpaired driver. Right?
Correct.
And you're aware that making a proper decision and the validity or the studies are based on the results of more than just the walk and turn and the one leg stand, right?
Correct.
It's based on the results of all three of those, right?
Correct.
Okay. And here we have evidence of the walk and turn and the one leg stand, right?
Correct.
Okay. And now with respect to the walk and turn, do you know how much Mr. Cruz weighed at the time?
I do not.
Okay. May I approach the witness?
Yep.
Would it help if you referenced your office report to refresh your memory? Did you bring a copy of it with you?
I have my supplemental report. I don't have the full office report.
Okay. And you understand that office reports, you know, they're not admissible as evidence typically, but I can ask you questions about things that you recorded that you remember, right?
Correct.
Okay, so do you see any indication of the weight?
The weight listed 270.
270 pounds. And you know how tall?
I had referenced 5'6".
5'6", 270. In your opinion, would that be at least 50 pounds overweight?
Couldn't begin to tell you.
5'6" and 270. It's probably more than 50 pounds, maybe 70, maybe 80, maybe more, right?
I'll take the word for it.
Okay. Well, that's something that, okay. And according to the NHTSA training, there's issues with the walk and turn, for example. When it was conducted on people who were 50 or more pounds overweight, right?
Yes.
You remember that? People who are overweight by 50 or more pounds may have difficulty performing the one-leg stand as well, right?
Correct.
Okay. And you talked about the walk and turn. And I'd like to ask you about what you observed. The state asked you to list the 8 things, we call them clues. Asked you to list the 8 clues that you were trained to look for, right?
Yes, sir.
I think you only listed 7. I think you left out stops walking. But that would be one of the clues, right?
Correct.
Okay. And you stated that he was unable to keep his balance during the instruction phase.
Correct.
Okay. And then you counted that off as a clue.
Correct.
And so part of it is these are called divided attention tests, right?
Correct.
And you tell the person to, in this case, there was no line. You asked him to imagine the line, right?
Correct.
So you're part of what you're scoring him on is if he stepped off the line, right?
Correct.
A line that doesn't even exist.
Correct.
Okay. And you asked him to put like his left foot on this imaginary line and to put his right foot in front, correct?
Correct.
Hands down by his side, right?
Correct.
That's not how we normally stand when we're talking to people, right?
Correct.
Okay. And then you scored him for not being able to keep balance while listening to the instructions, right?
Correct.
Okay, do you know what you're supposed to look for to score that clue?
In terms of,
I mean, you're telling the jury that you observed that clue. You said he couldn't keep his balance during the instruction phase, right?
correct,
And that means that's a sign of intoxication, right?
correct,
Well, through the NHTSA manual, the purpose is to train you on, here's when you score that clue. If you see this, then you can score it as a clue, right?
correct,
Okay, so there's different criteria for like missing heel to toe or stepping out flying. There's different criteria it teaches you to say, okay, you score this if you see this happen, right?
correct,
And sometimes it says, but you don't score it if you see just this, or if you see this, you don't score that clue, right?
yes,
Do you remember what it states about the criteria for scoring that clue of not being able to keep his balance during the instruction phase?
I don't recall the verbiage, no.
May I approach the witness?
Yeah.
If you, I'm gonna be asking you from, so in session 8, so that's the main chapter where they talk about the administration of the field sobriety test, right?
Correct,
Okay, and in session 8, regarding the instruction stage clues, there's 2. He can't keep balance during the instruction phase, or he starts too soon, right?
correct,
Okay, but it talks about what you need to look for to score that as a clue, right?
correct,
And you don't want to come here and tell the jury you saw clues that you thought were intoxication if that's not what you're supposed to score. I mean, you want to tell the jury accurate clues of intoxication, right?
correct,
Based on how you were trained, right?
correct,
All of these tests have to be done in a standardized manner by every officer that does them anywhere, right?
correct,
Okay, so misscoring a clue would mean telling the jury evidence that the training and NHTSA says, you know what, that's not a sign of intoxication. We don't want to do that, right?
correct,
Okay, so regarding, have you had a chance to look at that page, session 8, page 44?
Yes, sir.
So because it's a divided attention test, so it says a person who is impaired usually can't focus on their, doing two things at one time. That's why you divide their attention, right?
Correct.
So that they may listen to the instructions, but they may not be able to keep their balance during that instruction phase, right?
Correct.
And it says to record this clue, and it's underlined, if the subject does not maintain the heel to toe position throughout the instructions, right?
Correct.
So on your camera right there, we didn't see any evidence that he broke his foot apart or broke that stance, did we?
No.
Okay. So even though NHTSA states record that clue, it actually provides more description, more instructions on how to score that clue, right?
Correct.
And it actually states feet must actually break apart or step off the line, right?
Correct.
We don't see any evidence of that on the video, right?
Correct.
And then the very next section, next sentence, underlined, do not record this clue if the subject sways or uses the arms to balance, but maintains the heel to toe position, right?
Correct.
So I think on your camera, I mean, to be fair, it looked like, I mean, he did ask you some more like clarifying questions about the instructions, right?
Correct.
And I think he put his arms up like this or something.
Correct.
I mean, using your arms for balance, he wasn't using his arms to keep his balance. He had raised his arms, right?
I took it differently, but yes, his arm went up.
Well, you don't see him losing his balance, is what I'm saying.
Per the definition, correct, no.
Right. I know there's another clue that you can score using arms for balance, but during this position, like, it says only score that clue if he breaks his feet apart from that stance and steps off of that line. And we have no evidence that he did that, right?
Correct.
But you are here, you scored that as a clue anyway, and you're here telling the jury, you scored that as a clue of intoxication. Right?
Correct.
But everything that you're telling the jury, I mean, it's got to be based on facts and evidence, right?
Correct.
Things that you actually observed, things we can prove from video, right?
Correct.
Okay. And there's so Deputy Perez, even though you did the sobriety test, he wrote the main offense report and was the primary officer, correct?
Correct.
And he ended up transporting Mr. Cruz downtown, right?
Correct.
Okay, but when officers work together, you supplement the office report, correct?
Correct.
And so you're basically here telling the jury your opinion of what you observed, right?
Correct.
And there's actually a scoring sheet that you can use to score clues on the field sobriety test, right?
Correct.
Okay, and you filled that out, right?
I don't believe I did. I believe Deputy Perez did.
Okay. Have you seen it or reviewed it?
I have not.
Okay. Have you used it before? May I put you in this?
Yep. I have.
I'm gonna show you a copy of what I'm talking about. Just, do you recognize that form?
Correct.
So there's a form with things already printed on it, boxes you can check to score what was observed, right?
Correct.
And you've used that in your investigations before?
Correct.
and you are the one that did the test, but you're saying you didn't fill that out?
Correct.
Okay, well, if you look, on that scoring sheet. And, so there's a place to record the truths that you observed, regarding the walk and turn, right?
Correct.
There's, in the one leg stand, right?
Correct.
All of the tests, right?
Yes, sir.
Okay, and then over on the right side, there's actually an allowance for you to use alternate tests, correct?
Correct.
And these, aside from the three that you talked about, but basically states that if a person is 50 pounds overweight, and they also talk about age, the studies have shown that if a person is 50 pounds overweight or more, or 65 years of age, or if they have an injury, that can affect their performance, right?
Correct.
So we're in agreement that if the person is, the weight can cause, can affect their performance on this balancing test, right?
Yes.
Okay, and this whole scoring sheet makes an allowance for that. It actually states that if a person is 50 pounds overweight, there's 1, 2, 3, 4, at least 4 other tests that are right there printed for you to use as tools, right?
Correct.
Okay, and on the scoring sheet, and in this case, I mean, there was nothing else done. All we have is evidence of the walk and turn. I'm sorry, these tests. Okay, you testified about the walk and turn and one leg stand, right?
Correct.
The alternate test, if you think, or whoever's doing them, if you think that weight is an issue, is to administer the alphabet test, right?
Correct.
And that's something that you're trained on. It's discussed in the NHTSA manual, how to do that, right?
Correct.
You get a person to, it's not just saying A through Z, you get them to start at one letter and stop at a different letter, right?
Correct.
Okay, so even though we're dealing with that situation with Mr. Cruz in this investigation, was there any alphabet test given?
Nope.
No, not by you or Perez?
Correct.
Okay, and the next one that's recommended, if you're in this situation, another test that's at your disposal is the finger count test, right?
Correct.
Have you ever administered that before?
I have not.
You have not, okay? That's the second recommended alternate test in this situation, right?
Correct.
Okay, and third recommended alternate test in this situation, the Romberg test, right?
Correct.
And that's basically where you have somebody stand, close their eyes, hold their head back, and estimate the passing of 30 seconds, correct?
Correct.
And then there's even a fourth recommended alternate test in this situation, and that's called the nose touch, right?
Correct.
And basically having a person, hold their arms out, see if they can touch their nose. And you can do all these tests and write down your observations, right?
Correct.
You could have done these tests, right?
Correct.
But you chose not to, and you don't have any evidence of all these other recommended tests to tell the jury about, right?
Correct.
And the purpose of it recommending these other tests is to account for different individuals. Everybody's different, right?
Correct.
Okay. But all of those are blank and no clues, weren't done, no evidence or proof to offer the jury of any of those tests. Right?
Correct.
And you're saying that, I don't know if you remember for sure, but do you see your name written on there? Is there any indication of who filled that out?
There is not.
And why do you think that it was Deputy Perez that filled it out?
Just typically the offer does report fills up the entirety of the packet.
Okay, so you're certain it was Deputy Perez?
I'm not.
You're not certain?
Correct.
I mean. Okay. Aren't you the one that's here that's supposed to be convincing the jury that you did these tests and you scored them? And, I mean, you said, my opinion is based on this, he was intoxicated, right?
Correct.
Is it, I mean, is it kind of important to remember who did what, who scored these clues?
Correct.
Okay. And you've had a chance to, I mean, you got a subpoena to be here for trial, right?
Correct.
You knew we were going to trial. Well, I guess you don't always know, but you knew it was set for trial and you got a subpoena to be here. You had a chance to talk to the prosecutors before trial, right?
Briefly, yes.
I mean, and that's not, it's recommended that you prepare and talk to them, right?
Correct.
And it's important to review videos, offense report, anything that you authored with respect to this case, right?
Correct.
Okay. I mean, would you be surprised to know that Deputy Perez did not fill this out and the video shows the one that was entered shows at 13 minutes and 19 seconds that you were filling out the scoring sheet? Would that surprise you?
Possible.
Did you want me to show that to you?
No, I mean, I'll take your word for it.
Okay.
I don't recall filling it out. If it's on video, then.
Well, I'd like to just play that one part then. I mean, it's important to make sure there's no misunderstandings and we give clear facts and clear testimony to the jury. Right?
Correct.
Okay. So if you're the one that filled this out, then it was your decision to not administer the alternate test for a situation like this, right?
Correct.
Would you mind starting at 13:19? Okay. Can you pause it? Do you want to pause? Do you recognize what's being filled out there?
Yes, sir.
And do you recognize who's filling it out?
Yes, sir.
Is that, how do you recognize?
My hand.
Okay, so that was you
Yes, sir.
filling out the scoring sheet you were talking about.
Correct.
Okay, so Perez didn't have any involvement in filling out that sheet.
I scored it. I mean, he did write on yes, but I scored it.
Right, but you're the one that administered all the tests and you're the one that made the decision consciously. We have the tests that we testified to and none of the extra tests, right?
Correct.
Okay. And it's important that facts be recorded properly, right?
Yes, sir.
And you're taught how to write correct offense reports, right?
Yes, sir.
And even in the NHTSA manual, it talks about, I mean, there's even chapters and lessons about report writing and how they need to be correct, and that's very important, right?
Yes, sir.
And so you did write a supplement that Perez incorporated into his offense report, right?
Yes, sir.
And you stated that upon exiting the vehicle, that's something that you can look at. And if a person has trouble exiting the vehicle, you might say that's a sign of intoxication, right?
Correct.
Or if you ask them for their license and registrations, sometimes people might fumble that, or, you know, we've heard give you their credit card or something. That's something that you're trained to look for. It might indicate intoxication, right?
Correct.
He didn't have any trouble producing those documents, right?
Correct.
He didn't have any trouble exiting the vehicle, correct?
Correct.
Nothing about the way he did that that this tells you to look for. Nothing about that was, indicated intoxication. Right?
Correct,
He did it in a normal manner, correct?
correct.
But you stated that upon exiting the vehicle, that Ignacio. You stated that Ignacio. I guess he leaned up against his car. Have you
I've read it, yes, sir.
who's Ignacio?
I do not know.
How did that get in it?
I can only make assumptions.
Well, I mean, did you proofread this before you submitted it as evidence?
I'm sure I did. I missed it, of course.
Mr. Cruz's middle name doesn't have a middle name. That's not even, Ignacio's not even a part of his name at all. Are you aware of that?
Correct.
Okay, so you're writing a supplemental report about things you observed about some person that is not on trial named Ignacio, right?
Can you say it again?
I'm saying you're here, or you wrote a report that is to be used as evidence talking about something you observed about a person named Ignacio that's not even a part of this trial. Right?
Correct.
Well, that's not good. Is it?
No.
I mean, somebody's on trial, we want to get the information right and accurate, right?
Correct.
I think with that, I'll pass the witness.
Any further questions?
Yes, Judge. So let's start from the beginning.
No, make it brief. Don't rehash. Make it brief.
Yes, Judge. In every DWI investigation that you do, is this stop based on erratic driving?
No.
Is it common to stop a car based on a traffic violation and that leading into a DWI investigation?
Yes.
If you hypothetically saw two vehicles speed, can you stop them at the same time?
No.
How do you decide which one to stop?
Typically the passenger vehicle.
As far as the drinking go, counsel pointed out that you didn't know if he was drinking alcohol. And you answered that he referred to a six-pack. What is usually when somebody refers to a six-pack, in your opinion, what is that? What are they referring to?
Beer, alcoholic beverage.
Is it uncommon to get assistance from other officers at a scene of a DWI investigation?
No.
Does the officer who conduct the stop, do they always take the person to the station?
No.
Is it common for another officer to come and take over the investigation?
Yes.
When you were talking about walk and turn, you named 8 clues, correct?
I believe I did.
And one of those clues is about balancing, correct?
Correct.
But there are 7 other clues that's not about balancing,
Correct.
including counting.
Counting itself, not a clue.
When somebody, like when you would walk and turn, how many steps are there? When you ask them, how many steps to take?
Supposed to be 9 each way.
So if a person counts 10, that can't have anything to do with their weight, correct?
Correct.
Uh, Doing a series of small steps turn, that has nothing to do with someone's weight, does it?
I wouldn't think so.
When you talk about an imaginary line, what are you really looking for?
To make sure they're walking in a general direction, not veering off to the side.
And in this situation, what did you see clearly?
He walked in a general direction, but did make some obvious steps off that would-be line.
The particular section that council spent a lot of time talking to you about, the stance and the balancing, that was the first stance before the test starts, correct?
Correct, part of the instructional phase.
And that counts for 1 out of the 8 clues.
2 potential clues.
2, okay. And the defendant in this case had how many clues out of 8?
I counted 5.
All right, anything further?
Just real briefly, Judge, yes, I'm glad you talked about that, this counting by 1,001, 1,002. If somebody repeats a number, that is not a clue of intoxication, right?
Say it again, I'm sorry.
The counting, 1,001, 1,002. If they repeat a number, or if they are having trouble with this divided attention test, that's not a sign of intoxication that you score, right?
Correct.
Okay. Just wanted to clarify that. And you talked about them stepping off the line.
Correct.
You scored that as a clue?
Correct.
Stepping off an imaginary line that doesn't exist. Yes? You scored that as?
Yes, I did.
Okay. I'll pass on this.
All right, may this witness be excused?
Yes, Your Honor.
Okay, subject to recall? Is he good to go?
He's good to go.
All right.
Yes.
All right, you're free to go. Thank you so much for your testimony. Be safe out there, and the step, it's a Lulu.
Right.
Yeah. All right, guys, we have some lunch for you. I think we have a lobster, a fillet, maybe a person playing a little, with a little, maybe not wine, but, so please go back. I'm going to make it quick, 10 minutes. Let's get in, let's get out, let's continue. Yeah? Okay, please.
All right, nurse.
So 10 minutes, don't go. So, don't go far, come back. We will start promptly at 1:15.
Ms. Reschke has to get on Zoom for an ALR hearing, but
Sure, but we're not going to wait. We got to continue.
I have a motion to suppress the stop to raise.
Then let's do it now.
Okay.
There's no sense in waiting. Oh, okay, go.
Sorry.
Yeah, sorry. Go take a break. You ready, Sina?
Yes.
You got it?
Okay.
Well, Your Honor, so yes, we verified everything. The police took the passport at the airport. They're waiting for him. The girlfriend actually has sent us screenshots as well. The passport is in possession in Harris County Jail. There's a tag on his wallet.
Yeah, you guys should still be able to get it. There's a way for you guys to get it.
Okay.
Talk to the deputies. I think there's a little white card that you guys can get.
Okay.
They'll release it to you guys and then we can bring it. To you.
Okay.
Yeah, but you can get it.
Thank you. Appreciate it.
Of course.
Good afternoon. I guess
Hi.
now, Judge. Nice to
Thanks
see
for
you.
coming to help. Mr. Henry, you okay? Oh, just, okay.
Going back to the.
Yeah, it says like property, like that, so they give you a form, fill it out, they take it, never take long to. And then one day they give you.
Oh, okay. All right. And then like, so do you know if I do that, I'm not gonna stay with the same place?
You go upstairs.
All right, cool. Well, we learn something every day. Cool. Big one, families. Yeah, we're doing it. No, it's like, also, let's see. Cool. All right, we'll see y'all. Because they're all the same, right? Three months.
Which one?
Did not know that.
You got it, Cena?
Yes, sir.
Okay, man. Good luck.
Let's try to get this, come back.
Yeah, I mean, usually it's the next day, so,
Okay.
yeah,
Thanks. Appreciate it. Thank you.
for sure, of course.
This one, the other one?
Yeah. Is this supposed to be yesterday? Yeah.
Just waiting on his big Dutch.
There we go.
Awesome.
Oh, you're waiting on far one?
Yeah, I'm kind of afraid of taking this off.
Don't, yeah, don't. Because we'll end up paying for it, you know? Took us 45 minutes to get that darn thing working.
I am here for Mr. Rodriguez Goldberg.
Are we doing a plea?
Judge, we're not, we're gonna release that. It is a very old case from 738 days.
What last name is Rigoberto
Rodriguez. Judge.
Rodriguez? Anything in particular you'd like? Just a
Judge,
reset or what?
he has a pending felony on August 4th, that's on August 4th. I just got a plea to it today.
Sure.
And it's a DWI.
If you want to reset, get a reset.
Okay.
Yeah, I mean, I get it. You're appointed today. You
Yes,
can be expected to do anything in a day. So as, you know, we'll give you some time, not 180 days, but certainly it's much, you know, a couple resets.
Perfect. Thank you so
Sufficient.
much.
And I don't know if this is new case upstairs, so I doubt a global will probably, you know,
Yeah, I think they're letting us handle ours separately.
just, okay, cool.
Yes, Judge.
Okay.
Thank you, and
Yeah, yeah, of course. So do we know if he's gonna bond out upstairs? Because I need to put bond conditions on him.
Judge.
Did he get-
as of right now, I have not been able to contact the felony attorney. I am going to shoot her an email to see what is going on. But his next court date is August 4th.
Tell me about the felony case. Was he in a car driving? Because we have him on a suspended license case. He picks up an unlawful possession of a firearm by a felon. Is he driving?
Yes, he was driving.
Right. So we need to do a no driving affidavit. I already did one. And he's in here. Yeah, I'm gonna revoke, and $102 is just way. Especially in light that I ordered him not to drive 2 years ago and he's popped now in a car, allegedly.
Judge, may I ask for a lower bond instead of a revocation on that one?
What do you think? So,
We would, lower on forfeiting multiple times, Your Honor.
how many times?
Uh,
At least two. And now he's picked up a felony and he's got a laundry list of priors. I mean, I think that 5,000. What's reasonable in light of everything?
Judge, because he's in jail and he's not able to report anything, I usually get appointed to that. It is 738 days old.
Yeah.
I'm asking for at least $600 bond. That he's able to bond out if he's able to bond out on felony.
So what I'm gonna do is, I don't even have pretrial here, so I'll have to do you have Mr. Rodriguez back there by chance?
No, sir.
No? So let's do this. I'm gonna raise the bond to 5,002 for now until I get him. And we'll do a GPS prior to release because he's been gone for 2 years now. He picked up a felony. In addition, he signed a no driving affidavit and here he's allegedly driving. So we can talk tomorrow, assuming we get him, so I can advise him of everything.
Yes, sir.
Yeah, I guess we'll do that. And then I'll do a bail order now so that you have something.
Thank you, Judge. May I be
Yeah,
excused?
for sure. And then do you want to roll to tomorrow
Yes, Judge.
or the next day, whatever you want? it's, yeah, okay,
Thank
sure,
you.
of course.
Judge, I'm ready.
Okay, we're gonna argue the motion to suppress. So I need, Ms. Shaw, please.
No way.
I don't need to. May I approach?
No, let's wait for them. But thank you. But just to be fair, let's just. No, no, of course. Yeah.
I know some
Do you want us to wait for you? Okay.
Hey.
All right. Are we, no. Hey, I'm revoking, Rodriguez back there and I need to do bond conditions, but he's not here, so we'll roll it tomorrow. Yeah, this is,
Hey, Maura.
it's on page, bottom of page 43.
Yeah.
So
Absolutely.
5,002. And then if you don't mind putting it on for tomorrow.
Just stop the beat.
That's what I said.
Yeah. That will eliminate all of that.
Okay, you guys ready?
Yes, Your Honor.
All right, so you have a motion.
Yes, Your Honor, I have a motion to stop. May I approach to offer case law?
Of course.
I'm giving a court and I gave you state a copy of Paul, the state. I'm moving to suppress the stop based on that I wanted to wait till the end of the testimony to see what he had to say. But the use of, he said the only reason for the stop was speeding and the use of radar technology. Courts have determined that to be novel scientific evidence. And in this case, it deals with.
Novel?
Let's try this. In this case, they dealt with a radar system called LiDAR. And that's what the whole case talks about, that any scientific evidence such as this must undergo the scrutiny of a 702 hearing. And it talks about the elements on page 3. To be reliable, scientific evidence must satisfy 3 criteria. The underlying scientific theory must be valid, the technique applying theory must be valid, and the technique must have been applied properly on the occasion in question. In this case, they stated that the state failed to meet their burden. They have the burden of proving that it qualifies under Rule 702. And in this case, we heard, I think he said he had some kind of stalker, dual something, but that's all we heard. And so I'm objecting to.
What are you saying?
I'm objecting that without more and without the meeting 702, the use of any radar must pass the 702 test. Because the courts have determined that it is scientific evidence, it's scientific instrument, must be proven to be reliable, and that wasn't elicited, there wasn't testimony about the methodology, the use of it in this situation.
Well, don't you have to bring it up or take him on board either?
Well,
I mean, now he's gone.
now he's gone, and I wanted to hear everything he said. The state had an opportunity to prove that. And he testified, I guess, everything that he was gonna say about the radar. So it's a timing issue, because if I raise that at that moment, then I mean, basically just tips him off that he's gonna try to then say, I don't know what he would say, but this is not a new, it's been around since 2000.
All right, so in the case that you provided me here, are you saying the use of radar was invalid? And it was held that the use of the radar was a bad basis for the stop? Is that what you're saying?
That is exactly what this case is. Additionally, I don't think there was sufficient evidence to extend the scope of the detention from a traffic stop to the DWI investigation. He never admitted to drinking any alcohol. I know that assumption can be made. He said drinking. The officer said he smelled the odor of alcohol from inside the vehicle.
He admitted to a 6-pack of beer.
He never said that. That's why we showed the video again. He said, he didn't say beer.
So where did the 6-pack come from then?
He said 6-pack.
Who said 6-pack?
Mr. Cruz did. But he never.
Oh, I see. Oh, I see. Okay.
It's just.
It's premature. We have another witness that he also admitted to the type of 6-pack.
Right. I'm sorry.
So that's one. And to respond to the case law that council provided, Marco v. State, that is from our jurisdiction.
Wait, Marco v. State, he's provided Hall v. State.
Yes, but Marco is the authority that applies to our jurisdiction, which does not agree with Hall v. State in this situation, in the way it
Are you saying, is that from the 1st or 14th?
what's that?
Is that's from the 1st or 14th?
Yes, Judge, it's from the first district.
Okay.
And it is a more,
Psych.
yes, I'm about to give it to you right now. So it's a unreported case right now, but it's 2015 Westlaw 505194.
Okay, 2015 Westlaw.
505194. And
Okay.
from the first district of appeals, it's a February 2nd, 2015 case, and it distinguishes this case specifically, stating that Hall relied solely on LiDAR technology, and that the defendant argued in that case that the arresting officer lacked probable cause because the state failed to prove the reliability of LiDAR device, which the officer used to determine the defendant was speeding. However, the Texas Criminal Court of Appeals concluded that our jurisdiction specifically distinguishes that case by saying that the deputy, like the deputy in this case, personally saw the defendant traveling at an excessive speed, which is what he testified to. And so it stated that this was distinguishable and actually criticized the Hall case for that ruling. So the Markle v. State case would be controlling here.
Judge, it appears to be an unpublished opinion, but we're trying to we're reviewing.
But he can still testify that in his opinion, he was traveling over the speed limit. No?
But he didn't say he was pacing him. He didn't say anything else other than he uses his radar. That's the issue.
That's not true, Judge. He said that he was pacing me, that she was going behind him. And that's how he realized that his speed was, he noticed him. There were other, council brought up multiple times, there were other drivers on the road that were going faster. And again, he explained, I followed the one that was going the fastest. You could see on his dash cam the speed clearly. I think he had every legal reason to stop the car. Or traffic stop.
I respectfully disagree. He did not talk about pacing. We didn't hear any evidence about pacing. If that was the method, there's usually more elaboration, how far they paced them, the speed. I think the state just asked him, what speed did you get up to? But it was clear that he used his radar.
And Judge Marcos distinguishes radar from LiDAR.
Which did he testify to that he was using here?
Radar.
He said, I think he said stalker radar.
Okay.
And Judge, we're printing out a copy right now, so I'm not sure.
I'm reading it right now.
Okay,
Thanks. So in this case here in Markle, they distinguish it because Hall is markedly different from the radar technology utilized by the deputy in the Markle case. So what all do you want to put for the suppression as is there anything else that you want to add to it?
It is the case, I think.
Or do you want to see the case law first and then?
Well, I think, Ms. Brasky has been researching that, if I can give her the last word.
Sure.
And, but it's not just the radar, but also the reason for asking him to step out of the car with no admission of drinking alcohol,
Okay,
not being able to place an odor of alcohol on his person.
okay.
And he didn't have any other signs, he said, of intoxication.
He did say that he saw,
Well, I-
ICI.
Well, let her finish real quick and then I'll let you address. So one and done.
Specifically responding to the Marple v. State case. What's distinguishable about it is that in that case, the officer also paced the vehicle. And he identified a different way that he could say that this person was speeding. So it wasn't the use of radar specifically or any sort of machine that would detect speed. This officer in the Marple case had paced the vehicle. We didn't hear any testimony from the officer today in this case about there being any sort of pacing that happened, or that based on the officer's training and experience, that he was able to conclude that he was going a higher rate of speed or a specific rate of speed. In fact, his testimony was about a specific rate of speed, which lends to the fact that he was relying specifically on the radar, the machine detecting function. And, okay, and the officer, he did testify that he was using Stalker, which is just a brand of LiDAR, so he was using a LiDAR system. Right. But in a separate matter, this Marple v. State case presents an additional issue because it's actually not binding over this jurisdiction or over any jurisdiction because it's an unpublished opinion. Unpublished opinions aren't supposed to be used for use in developing legal arguments or even use in an appellate court. And that's because the purpose of an unpublished case is to step aside from what the general opinion would be and say, okay, well, on this very specific set of facts, we're going to make an exception outside of the rule. Unpublished cases are not intended to be used for all of the other cases. They're not binding. According to the rules of appellate procedure, they're not binding. And so while this unpublished opinion may have come out of the first district, it has no binding authority over this court or over any court in Texas. So those two reasons.
Okay. You ready?
Judge, we saw, I mean, other than the officer saying that he was right, you know, he was conducting the stop and he was right behind the car. We saw a video, literally a body cam video of him in the same car following the defendant, seeing the speed until they stopped. If that's not pacing, I don't know what is. And it was a while where it showed the speed was high and it kept going higher, and then it came down and you could see it dropping to zero when they stopped. I mean, and that's in evidence. That's a video that's in evidence.
Okay. All right, I'm gonna deny your motion to suppress, Mr. Flood and Ms. Brasky. How long has it been? Or wait, let me do a plea. We have a plea first. Let's do this plea so they can get out. And then after that, um, guys, do you mind grabbing the defendant? I think you should be outside. Do we have Luis here? Does it need trans? Oh. Kendra, are you ready?
Yes, I am, Your Honor.
Okay.
How do I turn
What's
this
the last
on?
name? Oh,
Page 4.
You guys,
and then after that, let's get the stipulation. Mr. Castro, so you know, you are not here alone. Your lawyer's here with you, but on Zoom. You're charged with driving while your license is suspended or invalid. You're facing up to 6 months in jail and or a $2,000 fine. You have worked out an agreement. They're offering you 6 days in jail for one or,
You only have 1 day credit.
so is he going in for? Kendra,
Yes.
you guys did 6 days in jail credit for only one. That means he has one more day to do.
No, well, then they made a mistake because it's supposed to be time served.
Judge, I'm willing to do 3 days if you are willing to.
Yeah, yeah.
I will do 3 days.
Okay.
Thank you. Thank you so much.
Okay. All right. The agreement is 3 days in jail credit for the, should we do one? He only has 1 day credit, right? So we'll just, for 1 day credit, you are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. This will go on your record. From now on, you will be facing a minimum of 30 days in jail. Do you understand? All right. How do you plead to this offense? Guilty or not guilty?
Guilty.
I'm going to find you guilty. I'll follow the agreement, send it you to it. Good luck to you, sir.
Thank you, Your Honor.
Thank you.
Yeah, just sign in this page and then also we put 3 days. Yeah, take this page, the first one, so you can be, so you can clean another code.
That's
Yeah. Okay. All right. See you tomorrow. Okay. How many more witnesses do you have, State? 3 more? Do you have any witnesses?
No, that's okay.
Okay, so we'll probably push until tomorrow then.
But we are going to be using, motion to suppress for Miranda issues and any testimony regarding anything after he was under arrest and subject to custodial interrogation.
Okay, I guess when we get there, just raise it. Just beware. Guys, beware that they're gonna raise this issue, so just.
And so the fear with that is that the identification that the 6-pack was a beer was after he was already under custodial arrest and interrogation.
Okay, I guess we'll get there when we get there. But Are you on the record now?
No, yeah, if you want me to begin.
Yeah, okay, let's go on the record. So defense, we're about to pull the jury in to start with the second witness, and the defense has just raised a point where they want to challenge statements made with regard to Miranda and Miranda warnings. Did you want to say something, guys?
We just ask, for a little bit more specificity on when the defense is alleging he was under arrest, just so that we can clarify kind of what we should and should not get into. And if we even have a disagreement, because we may agree that the state.
Defense?
Yes, so that's a part of the overview redactions. From
That's not what it is.
He read the TIC 24 in his car, arrested, which starts out during the arrest.
Okay,
And then that's when he questioned him more, what were you drinking? And there was never any Miranda there. So you're asking what point? That's the point.
Thank you, Judge. Well, I just wanted to.
so does that happen like immediately?
It does not happen immediately. I just wanted to clarify, because we do agree after that point, I want to review this. Yeah, just a moment.
Yeah, of course. Hey.
I hope you stay.
Hey, I'm cool with whenever. I mean, nothing's really, you know? Trials. Trials. It's a good question. It's my wife's birthday today. I know, man. Dang. What should I get her?
Give her enough of anything.
I know, right? That's right. Yeah, she told me the same thing too.
You should have told me. Because I would have scheduled something.
It's always good. A belated's always good too, really. Okay, I did get, but
We'll be back tomorrow.
no, for sure. No one. I mean, yeah, we'll probably.
Maybe Thursday.
No, hell, no. Hey, maybe 3. I mean, take one, maybe 1 week. I mean,
Depending on this one, you don't have to
Right.
finish this one.
yeah, we gotta finish at least one.
So whenever
We'll see.
we finish.
Depends on how.
I can,
All right, what's the deal, Pickle?
yeah, you judge. It's fine.
Okay,
We're not gonna
so
get into it.
I guess in an effort to be more expedient, to redact, I guess a cut audio.
Yes, Judge. So the portion after the DIC, we would be fine to mute. I believe the prior officer already testified that the defendant stated he had a 6-pack, stated he was
Yes.
drinking. The only thing that's after the DIC is the specific type of beer he was drinking.
Okay,
So we'll agree to mute.
yeah, so it's stipulated to, guys, defense, up until what part? So at what point can it go back on, I guess? For purposes of the record, I would say if you can give me a number so that we can put, so the record's clear. So this is with Officer,
Officer Perez.
so Officer Perez has his own dash body cam. All right, so we're talking about Officer Perez body cam. So from the moment he says you're under arrest, it's off until what time? And then defense, are you okay with that time?
Not from the time that he says you're under arrest, because that's basically the reading of the DIC.
Okay,
Anything that the defendant said after that.
got it. Okay, fair enough.
We'll
Sure.
put that out.
Yeah.
It also has, the HGN testing, so,
Yeah, that's got to come out
check
too.
that out. Yeah.
Right. So tonight, we're going to break. There's no way we can finish tonight. So what I would say is give it to your guys tonight with the understanding we need this part cut out, we need this part cut out. So tomorrow when we regroup in the morning, it's ready to go. So we don't have to waste time setting it right back down, you know?
And, just to be clear, because I have all the witnesses here, should I maybe let one or two go?
No, let's just wait at least because I'm going to cut loose at 3. Okay. Let's get through at least one more witness.
Donald Warner there and, Lawrence Carter.
So let's get through one more witness. We'll break for the day. And then,
We do have a motion to suppress the breath test.
of course,
as well, and it's-
I would expect nothing less. But
Saying because they have a text in here now and they were here before, so I just wanted to let you know.
got it. Well, thanks.
We would need that.
But wait, give me the time for the video to end because I want to make sure that they're okay with this. Do you know what time ending as far as his statements are concerned with regard to the Perez video?
So, Judge, I'll give you where the video should start and where it should stop.
Okay, sure.
So,
Yeah.
The HDN out. Walking turns starts at. Should I give you the time, timestamp? So it would be 4:08.
Hold on.
46.
Hold on. Let me write this down. So. Okay, well, give it to me.
So 04:08:46 will be where the video starts.
And that's on
Miranda.
on the actual body cam, when you're looking at the body cam, that's what's on there, not until the disc gets up.
Okay.
The time of the day.
Okay. That's when, as far as he starts talking, right?
It starts from walk and turn.
Is when he starts questioning it.
So in order to cut out, so to clarify, to cut out the HGN, the video will need to start at that timestamp she just gave. So that's
Okay.
the beginning of the video.
Got it. Okay.
And so now to go to the GIC part.
Are you guys looking at this so we can be on the same page?
So the walk and turn is on this line. View of walk and turn. Yeah.
It's the DNC stuff.
It'll be, 4/19/25.
What's that?
It's, 4 AM, 4 AM, 9.
No, I know it.
That's the end of, a DIC meeting. And anything.
When the video, we can start listening to it.
Stop, start with the 408.
Okay? Oh, I see.
Yeah.
So it's 04, you said 19?
And 4/19 is
Any seconds?
25.
So at that point, you stop the video, so no, they can't hear
Yes.
Okay.
Anything said after
it.
that.
When can it come back on?
I don't believe it needs to come back on it.
Okay, so that's basically, we just turn it, so they're only watching around 11 minutes of video then for this particular, is this Perez? All right.
And most likely, not even the whole DIC, I just wanted to show the jury that he did leave the whole thing.
Whatever, yeah, it's great. Okay, whatever you want. Great. As long as it's just not, they don't hear any unmirandized.
Yes. That would be audio, okay. The video, so there, you can upload. I didn't just cut the video.
Are y'all contemplating life over there or what? Are you, I'm just kidding.
This price is, cross Perez, but I'm not interviewing anything.
No, but we're good, right? Okay, so
So we just think we know that we're not going with the last two witnesses, can I let them go?
I don't know. You want to challenge the breath test and the person's here. How long are you going to take with this witness, Perez?
Really asking, that's
Right.
probably better.
I would say let, is it the technical supervisor you need?
The text,
Right, so let the third one go, not the technical supervisor, just in case. Okay? And then let's go ahead and pull that guy, Officer Perez, so we can at least get started with that. And hopefully we can be done at that within 45 minutes to an hour. I don't know. We'll see.
Yeah, let's.
Everything okay?
I was just asking if there was any instructions before he takes us in, I'm not going into the things that he learned after. Using the city and using.
Smells like food. Like fish.
Just to clarify, I just want to make sure I'm not letting the wrong person go. I have, Officer Alan Torres who took custody. And then I have the person who conducted the breath test and the.
That's the operator.
For the machine.
Right. You don't need the operator for the,
That's Don Garner. We
Yeah.
don't need him for the hearing.
Okay.
you sure?
Okay, just making sure.
I don't need him.
Okay, just, yeah,
See.
all right. We just need the technical supervisor.
Yeah.
So Mark, again,
Um,
for the day.
right, I'm not gonna question Garner for the hearing.
All right.
Just want to make sure everybody gets it.
Touche.
And you did instruct him not to talk about the HDN or anything after the NC. Okay. And you specifically did that as well. Yeah. Yeah. Here I said nothing happened.
Come on. Let's go. All right, you ready? All right, let's go.
Eyes for the jury.
All right, state you ready to call your next witness?
Yes, John.
Please.
State Falls Alan Torres, Deputy Alan Torres.
Okay. All right, this witness has previously been sworn. If you'd like to come take a seat. All right, thank you for coming, Officer Perez. I'm going to ask you to please speak loudly, clearly. If you hear the word objection, just stop until we've addressed it, and then you may continue. All right, please. Okay, your witness.
Good afternoon. Can you please state your name, your last name spelled out, please?
Yeah, my last name is gonna be Torres, that is T-S-N-C-O. First
Hold
name
on, hold on. You need to speak.
is T-R.
Yeah, Judge, do you have that volume? It may not work, just keep your outside voice.
My last name is gonna be Perez, P-E-R-C, as in secret. First name is gonna be Alan, A-L-A-N.
And how are you currently employed? What agency?
With the Harris County Constable Precinct 4.
Are you assigned to a particular area?
Yes, I'm assigned to Central.
And as part of your training, do you handle, or were you trained on DWI investigation?
Yes,
Do you receive training pertaining to intoxicated drivers?
yes.
So can you tell us a little bit about your background and training?
Okay, so I have 40 hours of training on the academy. And then I also have another 40 hours of training from my agency.
How long have you been with your agency?
2 years.
How many DWI investigations have you been a part of or conducted?
Part of investigation, multiple. By my own.
I didn't hear that.
I've been on part of the investigation for DWI's multiple investigation, but on my own, 3 investigations.
3. And I want to direct your attention to May 24, 2025. Were you on duty that day?
Yes,
Did you happen to, do you remember what shift it was?
yeah, it was gonna be night shift.
And what was your assignment at the time?
I was a state unit on that day.
What does that mean?
A state unit is we're specific in an area where we conduct traffic stop for reckless driving or DWI.
Do you remember receiving a call from or call for assistance from a deputy Ryan?
Yes,
Do you remember attending the scene?
yes.
And what do you remember? What was the scene about?
It was a regular traffic stop in relation to a speeding violation.
And when you got there, what was your understanding of what the stop had turned into?
Yeah,
Things like hearsay or personal knowledge.
I'm sorry, say it again.
Things like hearsay and a lot of personal knowledge.
Well, he hasn't said anything hearsay related yet, so I'm going to overrule that. Just please only testify to things that you have personal knowledge about, okay? All right.
So when you arrived, what did you observe? What was happening at the scene?
When I arrived to the scene, that day for Ryan, he was making contact with the driver of a motor vehicle.
May I approach your honor?
Yes.
Do you recognize what has been pre-marked as State Exhibit 3? What is it?
CCD.
Do you know what's the content of the DVD?
Not very common.
And have you watched it before?
Yes,
How do you know that you've watched it before?
because they showed it to me and I tried to recognize it.
If you don't mind, if you can speak up a little bit louder so the jury can hear you also. And do you know, to your best knowledge, does it accurately depict the events of that night?
Yes,
Has it been altered or changed in any way?
no.
Judge, now the state moves to admit state's exhibit 3. May I send it to defense?
Please.
We know additional objection.
Sure. Okay. It'll be admitted.
May I call the state's jury?
Yes, ma'am.
Part of your body camera. So just by watching the beginning of it, do you know, can you tell us what's going on here?
So at that point, he's conducting an investigation for possible DWI. They conducting part of this investigation.
And that's field sobriety test, correct? And, do you know what this test is called?
Yeah, walking.
Okay,
And by the side, stay like that until I say move. Like, when I begin, I'm gonna take your 9 kills step down line. You can leave that on the ground, you can see the small step, and you take your 9 kills back down the line. Ready? Now look like this. 1, 2, 3. Still on top of the 9. You got your legs down, you take the small step. You take 9 more down. 1, 2, 3. Always need time. Okay? I want you to count out now. I want you to look down your feet. I want you to keep your hands by your side. And I want you to keep going until you get all your stuff. Understand something still, okay? Say, go say 1, 2. 9 down, right? 1, 2, 3. All the way to 9. You want to leave leg on the ground? You take 3 small steps. 9 more back down. 1, 2, all the way to the 9. All right? So, any questions? Okay, do it again. So 1, right? You take first step. 1, 2, 3, 4, 5, 6, 7, 8, 9. All right. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10.
based on your training and experience with the DWI investigation, and walk and turn, do you see if the defendant had any clues of
Yes.
intoxication?
Yes,
Can you tell us what clues do you see?
he started from giving state to star. He started with the wrong.
Say that again.
He started when they were giving before star. He actually started with the wrong foot. And he don't count that up. And he was using his arm to balance.
Did you notice how many steps he took?
Yes,
How many did he take?
10,
And how many steps?
9,
Did you notice the turn?
yes,
Was that a proper turn?
no,
I'm gonna move on to the next test.
Get together here by your side, okay? Like I tell you again, the leg of your choice, put it straight up, you can put 6 inches off the ground, you can put it over the ground. Like if your hand by the side, you can look down your foot, you can count down, down to 1, down to 2, down to 3, so on and so forth, until you stop. Okay, your hand by side, make sure you look down, make sure you get that leg straight, 6 inches off the ground, count up. Any question about that? Just one question. I got a 1,000, 1,001, 1,002, 1,003, you go to the page up. Any other questions? Okay. You begin. 1,001, 1,002, 1,003, 1,004, 1,005, 1,005, 1,006, 1,007, 1,008, 1,009, 10, 11, 12, 13, 14, 15, 15. I'm over here. Stop this right now.
Okay, on what you saw with the one night stand test, do you see any clues of intoxication there?
yes,
What clues do you see?
counting in the wrong way and he was not balanced on the right way.
Did you see anything else?
No,
Did you see him put his foot down?
Objection.
Sustained.
I'm going to show you all. Gentleman approach.
Yes.
I'm showing you what's been more, pre-marked as States Exhibit 2. Do you recognize it?
yes,
What is it?
it's gonna be the CF 24.
Can you say that?
It's gonna be the DFC 24.
And, how do you know that this is this a accurate copy of the DSC 24 that you used that night?
Yes, it is.
Do you recognize your handwriting on this?
Yes,
Does the defendant have to sign this form?
yes,
Do you see the defendant's signature?
yes,
Has this form been altered in any way?
no,
Should I tender to?
It's a state's 4, correct?
State two.
Was it two?
The other one was three, but this is, two, I just had to. I got it out of order.
No objection.
Okay, it'll be admitted, states too.
So, after the test, we see you go into the car. I want you to tell me, what were you doing at that point?
After the case was complete, he was placed on the chain, he was surrounded by see on a patrol vehicle.
And, I'm gonna show you.
So I'm gonna review your DIC 24. I want you to prepare. Well, do you prepare?
So can you tell us what is a DIC 24?
DSC 24 is gonna be the legal rights that he has in case he refused or he wanna provide a break sample of his blood, and it's gonna be the consequence.
Are you required to read the whole, DIC statutory warning to the
Yes.
citizen? Did you read the whole thing to him that?
Yes.
And at the end of the reading, what was his decision?
He consents to provide a break test.
And, did he sign the form?
No, he didn't at that moment.
Did he at some point down the line sign the form?
Yes, yes.
Manager?
English or Spanish? English, okay, so you're under arrest for an.
So I wanted to ask you about this. You asked the defendant, do you want me to read this in English or Spanish? Why did you ask him that?
Because based on the accent, I mean, it's not discrimination, but I mean, it can be either Spanish speaker or English speaker. Just really depend.
And we all heard, what did he choose?
English.
Offense arising out of acts alleged to have been committed while you were operating a motor vehicle in a public place or while travel while intoxicated, or an offense under section 106.041 Alcoholic Beverage Code, you will be asked to give a specimen of your brain and or blood. The specimen will be analyzed to determine the alcohol concentration or the presence of a controlled substance, drug, dangerous drug, or other substance on your body. If you refuse to give the specimen, that refusal may be admissible and a subsequent prosecution. Your license, permit, or privilege to operate a motor vehicle will be suspended or denied for not less than 180 days. Or not, you are subsequently prosecuted for this offense. If you refuse to submit to the taking of a specimen, the officer may apply for a warrant authorizing specimen to be taken from you. If you are 21 years of age and submit to taking of a specimen and analysis of the specimen show that you have an alcohol concentration of 0.08 or more, your license, permit, or privilege to operate a motor vehicle will be suspended or denied for no less than 90 days, or not, you are subsequently prosecuted for this offense. If you are younger than 21 years of age and have any detectable amount of alcohol in your system, your license, permit, or privilege to operate a motor vehicle will be suspended or denied for no less than 60 days. However, if you submit to taking of a specimen and analysis of the specimen show that you have an alcohol concentration of less than 0.08, you may be subject to criminal penalty less severe than those provided for under Chapter 49. Penal Code. If you submit to taking a blood specimen, the specimen will be retained and preserved in accordance with Article 38.50 Code of Criminal Procedure. If you were operating a motor vehicle and you refuse to give a specimen or provide a specimen that show you have an alcohol concentration of 0.08 or more, you may be disqualified from driving a commercial motor vehicle for a period of no less than 1 year. You may request a hearing on the suspect or deny. These requests must be received by the Texas Department of Public Safety at its headquarters in Austin, Texas, no later than 50 days after you receive or are presumed to have received notice of suspension or denial. The request can be made by writing, demand, fax, or other form prescribed by the department. I certify that I have informed you both orally and writing of the subsequences of refusing to submit to the taking of a specimen or provide a specimen. I certify that I have request your signature below and notice the voluntary consent to taking of a specimen. I certify that I have provided you with a complete and true copy of this statutory warning. Now I request for a testing of your break of law. Which one? Do you want a consent for a break test or a law test?
Break test?
You want to do a break test. A break test is mean that you consented that you're gonna blow in the machine.
Yeah.
If you refuse to do that, I'm still gonna get a warrant on your blood, and then we regardless gonna find out. Okay. So which one do you want to do?
I think I'll give you the answers.
You want to do the break test? You want to consent on that?
Yeah.
Okay. Good.
Okay, so after the defendant consented to provide a breath test, what did you do?
Well, he was based on the custody, he was transferred to Young Processing Center downtown.
Okay, and did he end up providing a breath sample?
Yes.
What is the proper procedure for providing a breath sample?
Usually it's a 15 minutes break where we have to wait.
Come up, please. Yes. Yeah.
Wait.
Okay. Okay, all right. So I'm gonna go to take a seat and then say that I guess you're done, and then we'll let them cross. Right, or do you have any, other than that, do you have any further questions for the witness?
Yes, Judge, I have the question about the process and the observation period.
No.
Yeah, oh, okay, other than, yeah.
Right.
Okay. I'll just pass on it like this full column.
Okay, okay, all right. Thanks.
Judge, I'll pass the witness.
Okay, please.
So you were a part of the STEP program,
Yes.
and that's called the Selective Traffic Enforcement Program.
Yes.
And it's a program that specializes and is supposed to focus on DWIs.
Correct.
And so part of the things that you need to be a part of this specialized program is be qualified by NHTSA, right?
Correct.
With the field sobriety tests,
Correct.
have a good understanding of the field sobriety tests. Right?
Correct.
And the goal of this STEP program is to increase arrests for DWIs around holiday times.
Correct.
And this program is something that is funded by grant money, right?
Correct.
And produces overtime for officers who are selected for it.
Correct.
Okay. And so you were the primary officer on scene.
Correct.
And you had created an offense report, right?
Correct.
And whenever you were in training, you learned how to create a good offense report.
Correct.
And part of that is writing things in detail chronologically, so if you're ever having to review back, you can tell what happened in that investigation, right? So it's important for it to be detailed and chronological, right?
Correct.
So I want to talk a little bit about whenever you first arrived on scene that night, okay?
Okay.
Okay. So you had first said that you made contact with Corporal Ryan, right?
Correct.
And then you said that you made contact with Mr. Cruz.
Correct.
And in this contact, you said that you observed the odor of alcohol, red bloodshot eyes, and slurred speech.
Correct.
Do you remember how far away you were from Mr. Cruz during this interaction?
About 5 feet, this.
And sorry, you stated it was good at 1:19. Okay, so what we see is that you just got out of your vehicle, right?
Right.
And then you walked over to where Corporal Ryan was and Mr. Cruz is.
Right.
And from this is your contact that you're making with them, and you're about, would you dare say, this far away?
Right, I gotta go close.
This far away,
Never mind. Around there.
right here? Okay, so from this far away, you were able to smell the odor of alcohol.
Okay.
And so the odor of alcohol was able to travel all the way through all of this distance, all the way to you.
Yes.
And you were able to see in this area, this far away, that you had bloodshot eyes.
Okay.
Okay. And then you were also able to observe his slurred speech.
Yeah, the way he would contact me. Corporal Ryan, yes.
Okay. And something that you had said on the box was, you had asked him about the GIC if he wanted it read in English or in Spanish because he had an accent, right?
Right.
And whenever somebody has an accent, they might say words differently than other people.
Right.
Right? And because somebody has an accent, it can commonly be confused for slurred speech. Is that fair?
Right.
And so with this contact that you made with them from this far away, you're able to observe those signs of intoxication. And whenever you first arrived on scene to talk to Corporal Ryan, he had asked you if you're comfortable doing the field sobriety tests.
Right.
And you said no.
Right.
And so even though you're part of this specialized program that focuses on DWIs, you weren't comfortable administering any of those field sobriety tests, the walk and turn, one leg stand.
Correct.
And whenever Corporal Ryan, so Corporal Ryan, he decided he was gonna do the standardized field sobriety test, right? Even though you're the primary officer,
Sure.
and even though the investigation was supposed to be given to you,
Correct.
right? Okay. And so what we can see is that afterwards, you and Corporal Ryan are discussing possible signs of intoxication based on the walk and turn and one night stand.
Maybe approach. Again, this is the part that they wanted, yeah. I can't hear you.
Come up, please.
The fact that it is here, so it's so the part that they wanted. Again, okay, getting done. What
I mean, what's going on?
I guess. Was.
Yeah, but it's keeps happening. You guys can't really. Please.
So after the field sobriety tests were completed, it's fair to say that you were having some difficulty identifying what, the clues were of intoxication.
No.
No.
Mm.
And so whenever we just watched the video with the prosecutors, right?
Right.
You had said some signs that you observed, right? Just based on the video,
Right.
right? What were those signs? I don't think I.
The sign will be for the walk and run and one day stand, which is gonna be in relation to the HGA and signs.
And so, I mean specifically the walk and turn, what signs, what clues did you observe?
That he can't balance on his own, and then that he would start before he was asked to start, and counting on the wrong way too.
Okay. And how many clues are in the walk and turn?
6. How many he has, or how many some total?
How many total clues are in the walk and turn?
6.
6 clues? Would it surprise you that there are 8 clues of the walk and turn?
What some misunderstanding? Do you want the total clues or do you want the total that Corporal Ryan are getting?
The total clues in the test of the walk and turn, how many clues are there?
8
There are 8 clues. Okay, what are those clues?
are gonna be either miscount, balance, either start soon, not making the right turn, and don't count them out.
Okay. And so you said that there are 8 total clues, right?
Right.
Okay, and you listed 5 clues.
Sorry.
Okay, do you not remember just right now what those 3 other clues are?
No.
Okay. And then on the one leg stand, what was the clue that you had said that you observed after watching the video?
From this video right now,
Yes.
it's gonna be the one that is counted double time, number 5, counted 2 times. And then also he was not able to balance on the right way.
So counting double times. Are you aware that that's not a clue for the walk and turn or the one night stand?
I don't know.
Sorry,
I know.
you're aware, okay. And so you were counting him off for counting double times and what was the other one?
He was not keeping balance.
Not keeping his balance. Okay, and so we can agree that counting multiple times isn't an actual clue that you're scoring for the walk and turn, right?
Right.
Okay, so really, you're saying that you only observed one scoreable clue, which would be balance.
Right.
And I'm assuming by balance, you mean that, what do you mean by balance?
He was like, so just stay in one leg stand.
Okay. Okay, so. Then. Then whenever, basically Corporal Ryan, did Corporal Ryan or did you make the decision to arrest?
No, he didn't.
Who made the decision to arrest?
He did.
He made the decision to arrest, okay. So I guess that makes sense that you were sort of surprised whenever he said, okay, it's gonna be a ticket in. And you said, really?
Objection, Your Honor. It's hearsay.
This goes to the state of mind, it's an exception in hearsay.
And also they're stepping again on saying you should let it pass.
Come up. Hold on, just hold on. Was that in the video that was not put in? Was that in the video that was not put in? What are you talking about?
Again, this is a conversation between the two.
Is this in the part that's been redacted?
It's not the protection.
I don't know, is it or not?
Conversation between the two of them. Conversations between the two. Yeah, that's new. So.
Right, right, it's from the time.
That part is not new. But I thought that it was. I'm Christian, that was the answer. And you're saying.
Where specifically is that? Please. Can you take the jury out for 5 minutes, please?
Yes.
Give me 2 minutes, guys, please, so you can, we'll give you a short restroom break,
I'll
please.
ask for the jury.
All right, be seated, please. So where is this in the video?
7 minutes and 55 seconds into state favor. Seven, 53 seconds.
Thank you.
Yes.
That's not correct. This is correct.
Of 0.08 or more, you may be disqualified from driving a commercial motor vehicle for a period of no less than 1 year. You may request a hearing from the suspect organized.
Before the reading of the BSC?
Yes, yes.
All right, give me 1 second. Find it. I'll be right back. I'm gonna go.
It's gonna be after the.
Yes. Any other questions?
This was part of your redaction.
Part of the reduction.
So anything, so this is the redacted version of the request, right? So this was redacted even before with today's redactions. And that my responsibility, any conversation between the two officers you guys wanted about. And that was part of it. That's why it goes straight after,
The timestamp that it ends in before she stopped it is around 4:12:20-ish. And then
it goes
based on the reduction, we always tested it, it skips to 4:14:49. I think there's this portion that is what I would requested to be gone. So it's 2 days for the actions before this day was for Kobe Ryan's body worn camera and then the dash cam for Perez. But the body worn camera wasn't discussed or agreed upon.
Okay, so what's,
I mean, that's the only reason that it is redacted. I have not touched the redacted version that you guys discussed.
is it in the redacted portion that she's talking about?
It was.
It is? Okay, you've opened the door, man. I've repeatedly back and forth and at least 4 different occasions have told you, just, you know, I don't know what to tell you. It's all fair game now.
But again, in all fairness, now we lost the look and we could have asked a lot of questions because of what they.
Well, so you can do it tomorrow. You can do it tomorrow.
And-
Tell the witness to come in and you can have at it. But
And I want to make something clear for the record. The previous redactions that we had discussed with the state were for Corporal Ryan's body worn camera and Perez's dash cam. But we had not discussed anything being redacted from Perez's body worn camera.
well, no, but there's a video that's not in, right? That's not supposed to be mentioned. Right?
And again, for the record. the
Right,
two
so
that
we
now-
didn't ask for these specific redactions for this video. The only thing that we asked for was for after the reading of the DIC and everything afterwards, for that to be redacted.
I understand about the redactions. I'm not talking about the redactions.
Okay.
I mean, from what I understand, this is part in a video that's not even supposed to be come in or being made knowledgeable to the jury because apparently it came in late.
That-
And
that's-
because of that, you guys don't want the video in.
So that was the dash cam that council was talking about. There was no redaction on those days where we just.
Right, we didn't let it in at all because it came in late.
But with this one, there were redactions of any conversation between the two officers by request of defense, and we took them out and.
No, wait, I'm confused. I'm confused. This, what she's just now getting into, what video is that in?
It's this video. It's this video, but the part that they wanted out, it was taken out. And now they're getting into it again.
So what part are you talking about? Where?
It-
Exactly.
It's right, it's right after, so there is a short conversation between the two officers. Right after the test is finished to the time that Officer Press starts reading the DIC. There's a conversation between the two of them. And defense had requested, from my understanding, that any, they had given us the time of any time that the two officers are having a conversations out of the videos that were gonna be admitted to be taken out. And they were taken out and they were tendered to defense.
So this is
Reviewed
part
this
in
morning.
Perez's video that we had all previously agreed to,
Yes.
that we're not getting into because they're part. I guess they're not in the unmirandized statements.
Yeah, they're not. It's just between the officers and, we went over them this morning, showed them, approved. So,
No, this for Perez's body worn camera,
This video.
this video specifically.
Perez's
we-
body worn camera.
Yes, we did not request those redactions. Those are the state's redactions that they made. And we did not have an opportunity to review them this morning. What we reviewed this morning was Corporal Ryan's body worn camera.
No,
And-
but earlier we were talking about Perez's video. After the Mirandized statements, we were gonna, from this point forth, everything's not gonna be get.
This comes before the part.
it is before this, it is before the Miranda's.
But still within the time that we had all decided to cut audio or video.
No.
I guess.
I think I can clarify, Judge. I think the distinction here is these are pre-trial reductions. Am I correct? Yes, that y'all discussed, and I think there's a misunderstanding about what defense. I think defense disagrees with what we are understanding was a request for reductions pre-trial. Am I correct?
So previously, before this setting, there was an agreement for redactions, and it had nothing to do with Perez's body worn camera,
Okay,
nothing to do. The other redactions were agreed to for Corporal Ryan's videos, but not for Perez's. That wasn't even spoken about because they weren't at last setting. They were intending on bringing Officer Perez. And so that wasn't spoken about. I think that the state may have thought that in prudence to redact certain things out of Perez's video, but it was not something that we had asked the state to do pre-trial. And it's not something that we had asked them to do today. The only talk about redacting Officer Perez's videos were 30 minutes ago.
okay. So what's your response to that?
Judge, my understanding was that, again, I wasn't on this case. It was Farwar's case. She had been working on it with defense. I wish I had that email, but I don't have it right now. But my understanding was I received the redacted version. She told me to make sure that only use that version. Because it was defense's request for them to remove any conversation between the officers, and they made sure that it is out of everything.
Is there any problem with the part that
The thing, I
The state,
have to
the,
refresh my recollection, Judge, so.
I thought that the statement that you're now alluding to is either in the video that's not coming in or within the part that we're not trying to mention. So
So because you didn't see what you did, one. From walking down, combine, Jackson, the part of things. So when you think, what the exact one?
yeah, that's totally coming in.
I'll do something.
Yeah, that's totally fine. There's nothing wrong with that.
I mean, that's again, maybe it's a misunderstanding, I don't know.
Yeah, I mean, I don't think so.
understanding was that
I think that's coming in. I don't think you've opened the door at all.
It's okay.
Okay, bottom line, that there's no problem with the door on that. That's coming in. I mean, if she wants to allude to it, then by all means, and she can have at it. Yeah, yeah. There's no problem with that.
Have to then, just,
So to be clear, Judge, so you're saying she can allude to it, but is there currently as it stands, what has been admitted does not include that portion?
Oh, well, whose video is that right there that we're watching right now?
This is from the file to show, and which we can admit for the purposes of this hearing, not a problem. But what's been admitted to the jury does not include that. what we just
So
watched.
somehow that's gonna, before you can get into it, mention it, anything, it's not even in front of, they've not seen, they've not, so beware that now, I mean, you can't. At some point, perhaps, but now it's not in evidence. Right, so at some point, it will, but, okay, so whose video is that one right there?
So this is Perez's unredacted, unmuted portion that's in our files before we made any of the edits to it that
Huh.
were requested. So I'm happy, we can download that and admit it for the purposes of the hearing to the court reporter.
Wow, that was redacted out. And so when you went up to the portion, they didn't even see this and they were supposed to. Basically,
Yes.
yeah. I mean, it is what it is. I don't know. I'm not placing blame on, I'm not placing blame on anyone, but we just need to get the right one played so that they can see it. And then everybody can make questions and crosses and recrosses and whatnot in the right way. So, now, how do we do that? Right? Because I mean,
I don't know what Ms. Bresky has in mind, but it should take a minute right now just to ask him, did you hear it? It's almost just kind of like.
well, but it still has to be, it's not even in evidence yet. I mean,
Right.
because
That's the way I was saying. You could have to approach, show.
incorrectly redacted.
Well,
You know what I mean? It's incorrectly redacted and it's never been played in front of the jury at all. So they have to see it before she can even cross on it. Or
I was thinking he just watches it and then she can ask it. If he denied.
what do you guys think?
Judge, so I think there's two options. One would be that she can simply cross him on his recollection. He's now reviewed the full video, and so he now can recall what he said in that moment. It wouldn't be based on the body cam, it would be on what he's reviewed for the case. The other option would be that defense could attempt to admit the unredacted.
That's what I was, that's the only, what I was thinking as well,
Not unredacted, but because there's still the custodial interrogation issue. Then you have a copy.
Take 2 minutes to talk it over. Take 2 minutes to talk it over.
Judge, we could, because the evidence itself has not gone back to the jury yet. If all of the parties were to agree, the state could put that portion back in.
I'm okay as long as defense is okay with that, you know?
So we could put that portion back in since it hasn't gone back to the jury yet.
Sure.
And just keep the same other redactions that we have previously, if that's agreeable to you.
So basically, we will amend the video to add that portion in and then make it just longer so that portion is in.
Yes, and that will
Okay.
take me about 5 minutes. So
Okay.
just need a little time to do that. There's nothing else that we.
Yeah, take a look to make sure there's nothing else that we're missing, please.
This part was also that if you want this part in.
Do you have anything on your pocket that is gonna be dangerous? Example, drugs, any fucking knife? I'm gonna test you down, make sure you don't have nothing like that, okay?
I mean, it should be the whole thing, you know, up until we get to the unmirandized part.
Is there any way to make the volume a lot louder? 'Cause I think what you're talking about is hard to.
Well, you can turn it up when we're playing it.
Go back to it.
I don't know, I was just saying.
I know it was barely audible. I understand. But you can always turn it up. I don't know if you can.
I'm just saying, we can turn the volume up, because that works.
Yeah, I understand. What he's saying is the specific part they're referring to, it's kind of it's fast and it happens pretty.
To be clear, the part where he's been being put in cuffs was initially requested to be taken out as well, or y'all don't care about that? No.
We don't care about that.
Okay.
So for purposes of the record, let me get it, when you get it done, let's review it and then make sure that no one has any objections and then we'll admit that one.
Yes, sir.
And maybe that'll be 1A.
Judge, I don't know what number it is.
Yeah,
I'll mix it
so
up.
this is Perez, right?
Yes, sir.
Perez, so it'll be 2A. So we know that 2 is the bad one, 2A is the correct one.
You, hold on. You have to go with what you admitted it as in the record. You can't just change it midstream.
No, I admitted it as 3. And DIC was number 2. I didn't second, but it was.
I don't,
It was just admitted out of.
It doesn't matter. You need to go with that number.
So
Yeah.
that's what I'm saying. DIC is number 2
okay, just do that.
and this video is number 3.
Judge. I think the question was asked, like, did you say really were you surprised when you were, when I said the gang or something like that? I don't think that question was answered. I think that's what we.
That's a point issue object.
On Corporal Ryan's video, on part of it that we've agreed would be redacted, right? To refresh his memory, state of mind, we want to show, just for this hearing, that part of Corporal Ryan's because you can hear it better.
No, but you can hear it here too. I heard it here too. I don't want to start getting into redactions because then it becomes a slippery slope. I heard it here. I did. I heard it.
What did you hear?
That what she alluded to. He goes, really?
Really?
I heard it. With the inflection and everything.
Okay, thank you. Okay.
Hey, Barwa. What happened?
For the purposes of the record, but I asked what you have as states exhibit 2, states exhibit 3, we keep. Okay, wait, 2, I don't understand.
Here is a video.
Here's a video.
Times are different from the other side. We want to know what time to start.
Yeah, I wrote down. So. Cool.
And 3 is a video.
Okay.
You said this was your queue. Victoria wanted to hold it till tomorrow.
You want me to unsign it? Okay.
It's in your queue.
Whatever you recommend.
This one?
Yeah, can you? find it
Yeah.
tomorrow
Sure, of course.
For Victoria.
Yeah.
Thank you.
Right now. Do you want to just leave it in there?
Can you, yeah, it's just one sign.
Yeah, got it. Done.
Are you okay with us amending what the numbers are? So they're correct for purposes of the record?
Y'all should do whatever you wanna do.
Okay, I just wanna make sure it's correct.
Yeah, I don't care either. I mean,
Whatever
really.
you wanna do.
So.
Is defense okay with it?
So what's in evidence, I need that as is. Whatever y'all do after that, I don't really care.
Understood, I just wanna, because there's double numbers, I wanna
Right.
make sure that we have it correct for the purposes of the record. Sounds like. whatever we put in is in the two, and also the video, but then two is also the DIC. And so we need to verify that the line volume on camera is just a one.
Actually, like Judge said, the BIC should have been 4.
Okay.
But we only admitted 3 exhibits.
I was thinking it was, first was Ryan's video, right?
Yes.
Then it would be, I mean, traditionally speaking, the second piece of evidence, which was the second video. And then while we're in this second video, then they introduce something else. So yeah, this is why we do stuff in order.
Oh, sad.
All right, are we ready? It's 3:05. We haven't even finished with this witness, man. Yeah.
I know you wanted timestamps for the record purposes. I've given these students as well. From the unredacted, unmuted body cam of Deputy Perez, which we will admit as State's Exhibit 3A. The timestamps on that are that from 000000 on the video file and 040446 on the timestamp on the video to 00.03.45 to 04.08.31 on the physical body cam timestamp. That portion would be needed. From 00:14:39, which is actual time of day, 4:19:25 on the actual video, to 00.20.26, which is actual time of day, 4:25:09. That portion would be needed. So this is after the ice.
I would say also have it queued up, ready to go, because she's gonna want to cross on it any minute. That way we're ready, so when the jury comes back, we don't have to just sit there and waste another 5, 10. Yeah, do you want to go ahead and maybe play it real quick so we know?
So this is just already agreed on actions. Like from. Before, regarding Miranda and the vision. Right, yeah. Okay. We can go to immediate later on. Some point.
All right, do you want to turn it up on the speaker right there? It's right on. Yeah, that one. Okay, turn up. Play it real quick, can you?
So when you take them, over the exact IC 24, I'll do something with this for you. Alright, so let's get it there, turn around, so you can have your hand back. Take them, over the exact IC 24, we'll go from there. I'll do something with this for you. Alright, so let's get it there, turn around. Start some. No part of the steps. You drop it down. So when you take them, over the exact IC 24, we'll go from there. I'll do something with this.
Okay. Are you guys ready? You ready?
Yes.
Okay. All right, bring the jury in, please. So we'll start you at the floor. Ms. Bresky.
All rise for the jury.
All right, everybody, please be seated. Ms. Bresky, you may continue.
So after the field sobriety tests were done, there was a discussion about what was observed, and then Corporal Ryan said, okay, we're gonna take them in, and you had a surprise reaction. Really? Do you remember that?
Yeah.
And would you mind playing?
So as you can see, this one. Walking out. Combine. Start some. No part of steps. Drop it down. So go ahead and take him, over the set, the IC 24, we'll go from there. I'll do a supplemental case in 4 years.
Thank you. Okay, so you were the arresting primary officer, but you did not make an arrest decision, right?
Right,
And you were surprised about the arrest decision, right?
right.
We passed the witness.
Okay. Guys, any follow-up?
So earlier, council alluded to, the program that you are in funded being by grant money. Does that affect decision in any way in, any DWI investigation?
No,
This investigation and what happened was about over a year ago, right?
correct.
And at that point, how many independent, if you remember, DWI investigations did you have?
Since
At that point, not since then, when on that day, particular day. How much experience with,
before that particular day or after that particular day?
so at that point, from before to that point, what was your experience?
If you mean like how much DWIs arrests I have?
Yeah.
Not that many DWIs arrests I have.
Is it uncommon for another officer to help with a DWI investigation?
No, usually it's suit officer in a DWI investigation.
Is it uncommon for a primary officer not to have administered the actual test?
Yes.
Is it uncommon?
Can you tell me like uncommon to me like?
So
usual?
is it unusual for one officer to administer the field sobriety test and another officer to write the report?
Yeah, it is
Unusual? Okay, so why did you all do it that way that night?
because Corporal Ryan was the one who initiated the traffic stop and he's the primary that would make contact with the driver.
So that was why he conducted the testing?
Yeah, that's a precision.
Okay. And why didn't he do the report?
Because as a corporal, he's not required to do it. There's a backup unit.
Okay. And so that night, other than observing the test, you didn't take any part of the testing, the defendant, correct?
If I conduct any part of the test.
Yeah.
Not really.
And you were only observing.
No.
So your knowledge and experience at that point wouldn't have affected the test or the result of the test.
Correct.
That's the witness, Your Honor.
Anything further?
You're not a certified drug test operator, right?
Judge, objection, this is speaking, that's right.
Yeah. Do you have an objection?
Yes, Judge.
What is it?
Relevance.
This goes to his credibility, his
Mm.
training and experience.
Sustained.
You do remember testifying earlier that, the reason that you didn't do the field sobriety test is because you weren't comfortable doing them, right?
Right.
Okay, so it wasn't because that was just Corporal Ryan's duties, right?
No.
Pass the witness.
Okay. May this witness be excused?
Yes, Judge.
Any recall? Anyone?
We may have to withdraw one, Judge.
Let's keep them on call, please.
Okay, we're gonna need you back, probably tomorrow. Okay, so if you don't mind showing up again at 9 o'clock in the morning or 10 o'clock in the morning, please. Okay, all right. Thank you so much. Deputy. Ladies and gentlemen of the jury, the state has two more witnesses, correct? I think it's probably a good time to break for the day, just to give you guys a break. I'm so sorry. I have to bring you back tomorrow so we can finish it up, though. I'll give you a little bit later start because we will have some housekeeping issues. So if you want to get here about 9:30 tomorrow, as soon as all of you guys get here, we'll start again tomorrow. Okay? I'm so sorry, and I'll see you guys tomorrow. As I told you yesterday, please do not talk about the case amongst yourselves. Anyone else, don't do any independent research, and we'll see you back tomorrow at 9:30. Okay? Thanks, guys.
All right, for the jury.
Okay. What do you guys want to do? Do you want to do the breath test now, or do you want to do it tomorrow morning?
What's that?
She's here if you want.
We can do it now. I don't think it'll take real long.
Okay, come on.
I have,
Are you okay with that, Ramona?
Yeah.
Okay.
so I'm gonna have a motion to suppress the breath test result.
Sure.
It's based on an issue with the observation period. I have marked defense exhibit 2, it's a USB. It contains 2 videos of the breath test room at the JPC, 2 different angles. Don Varner's in it and Perez, but I'd like to still admit it for the purposes of this hearing.
Okay. Sure.
And send it to,
I'm sure they already have it regardless, you know.
okay,
I'm sure they have it anyways.
do you, you got it, read the plan?
It's just if you're getting into the observation period, then the person that can testify to that is Officer Perez
Yes.
or, Donna, or, it's just like a.
Right, so.
But the reality is the technical supervisor will testify as to why it matters. All they do is they sit there and observe. They can't testify as to why, how it's important, how it'll affect it and everything else. That's why the super is the person to be.
In my experience, it comes down to the technical supervisor, and everything else is on the video.
Yeah.
But it's, the observation period is not on the video, so that's why I'm saying.
And they won't give it, like Varner and Perez, like Judge said, they won't give it an opinion. The text is a person that would come in and say,
If you want to call that person tomorrow, I guess maybe we should just wait till tomorrow till the person's here anyways, in case she wants to call them. So it's just,
that's fine.
you know what I
That's
mean?
I'm saying,
'Cause
they don't need it for the hearing. I can't.
you tell me what you want to do. Do you want to wait or do you want to do it?
Yes, Judge, because counsel is saying the suppression matters based
Okay,
on the
so,
observation.
all right, so let's do this. Let's meet tomorrow, 9 in the morning, and let's just get started promptly at 9, not 9:30, just at 9, get here. I'll be here at like 9:05.
Okay.
Okay, and then let's resume tomorrow and just tell them, sorry, just be here tomorrow at 9 in the morning, and then we'll start with suppression hearing then. That way, hopefully, by the time they all get here by 9:45, can just resume with whatever the result is. I don't know. Okay? Have any kind of case law that you have supporting your position ready. You as well, you know what it is. So just be ready with any kind of anticipated issues with the observation period, you know? Yeah. Okay. All right. All right. We'll break and we're in recess until tomorrow morning.